We're about to get underway with the final session of the inquiry session into landscape and visual. Before we do, we just wanted to clarify a couple of points on the site visit that was mentioned yesterday. The purpose of which, from our point of view, will be to look at the route and gradient of the access track and the siting of some of the borrow pits where possible from a vehicle. And just wondering if we can get an update from your side as to the possibilities.
Yes, sir. Is my microphone working? Mr. Baird, to my left, who may speak in a moment and clarify detail, has arranged with the Fasque estate that we can have a driver and a vehicle, a maximum of 5 people in the vehicle, so 4 people on the parties. And that takes us around the Fasque side, but there's also the Glendye estate, and we've organised the same arrangement with the Glendye estate. But this is going to take more time in the afternoon. And I suggest, therefore, that if we make the progress, which I fully expect we will make today, then we should start at about 10 a.m. or as early as you want, and make sure we get it all done in reasonable time. It'll all be vehicular. There's no real walking involved. We can do it that way. And yes, we'll see the borrow pits. Yes, see the access track. Yes, also, with your permission, go to the Mount Paddock area as well for a more general appreciation of the site and some of the issues that have been talked about in terms of wildness characteristics.
And the 5 persons referenced there, is the driver the representative from your party, or is that?
So Sarah Fletcher, Sam Oxley, both of you, and the driver.
Okay.
Now, I know that there are other parties, I'm aware of that, but we've only been able to organise one vehicle.
Okay.
At this, I mean, no complaints. We wanted this. It is short notice, but that's our fault. So we have one vehicle.
Right. Well, we'll have a discussion on that and look at what options we can do and just make sure that
yes,
we don't think there's any prejudice to other parties and,
of course,
and discuss with them as well.
Yeah.
Okay. Thank you. We'll look to do that during the break at the end of this session, and we'll be able to give an update before we go into the first hearing later on today.
I asked to point out by my instructing solicitor that, of course, you're going to be sitting closer than 1 metre to each other inside this vehicle, but as long as you take that into account.
Open the windows.
Open the windows. That's a great idea.
And hope it isn't raining.
It's a good forecast for tomorrow. I think we'll be okay.
Well, what we'll do is we'll hand over to yourself today for continuing yesterday's session, and then we'll reconvene on this after the break. Thanks,
sir. Just have one additional preliminary point, and that relates to the email exchange between the case officer and Mr. Strawn, Commander Strawn, I'm sorry, relating to questions that he would like to put to us. We're very happy to answer them, but I assume that will be in the community session. I say that because some of the questions are for Sam Oxley. Who will be there.
I think a lot of what was raised in there is being covered through the community session topics that are down anyway. We'll review the questions. We only got sight of those this morning as well, so
I understand.
We'll review those ourselves, and if there are any elements that we don't feel is appropriate for that session, then we'll make a comment on that.
Okay,
later.
Thanks very much. Very well. Good morning, Ms. Fletcher.
Good morning, Mr. Trinick.
As
Good
often
morning, Ms. Haywood.
Sorry, apologies.
Mr. West.
As often happens through examination, the concept of diminishing marginal productivity sets in and asking too many questions. Or I think they've already been asked, or they weren't very good questions in the first place. And overnight I've been through and culled quite a lot of what now appears to be repeat material, because our discussions have gone wider than anticipated anyway. So I think I've got about 3/4 of an hour. And that's why I have the confidence we're going to make it to the end of the day. Just as a point of clarity, first of all, we've had references to Craig Souls. And just for the reporter's note, I want to make clear the Craig Souls we're talking about is the one by viewpoint 9, Mount Ean, and not the one by viewpoint 10.
That's correct, yes.
Thank you very much. Now, I want to just tackle wildness with you. And for that purpose, if you could get out, challenge the technology here, 3 maps. Just try with 2 maps to begin with. It's your Appendix 3, Figure 4, and the inquiry map D1. I may also make reference to Sam Oxley's Appendix F, Figure F4 map. If people have that hard copy, might as well get it in front of them.
Thanks. Did you say F4?
F5, I'm sorry, Sam Oxley. It's the composite map incorporating all the layers. Are we ready?
Yes.
Thank you. Now, in chief, orally, you, by reference to your figure 4, drew a connection. I don't know. You explained that the green area from the park could be seen to extend east towards Mount Battock and then south into Glendye. You described that, the green tinge, which continues across east and then south.
As presented on the both wildness maps, the relative wildness, you can see that the higher scores, which are the green, come from the edge of the park round to the north of the site and then down into the site.
Indeed, I remember. Just as a question, was Glendye or any part of the area immediately to the north ever, to your knowledge, in a search area for wildland?
I can't answer that, I don't know.
Okay, that's fair enough. As to the area to the north of the Glendye Red Line site, that includes Mount Battock, and it also includes further east along the ridge, the Bielach that you described.
Yes.
And I suggest, just as a matter of fact, never mind the interpretation anyone puts on it or the wildness attributed to the area, that when the reporters get there, they're going to see not only very deep peat hags and erosion, there's a lot of erosion up there going south from Mount Battock, but also evidence of shooting. There are 2 quite large buildings by the Bielach and a hard standing relating to shooting activity. That's right, isn't it?
I actually can't remember, so I'd have to see it on site tomorrow.
You can't remember?
Well, I don't actually physically remember seeing those buildings, so I'd have to see them tomorrow.
Okay. Well, I suggest that when from my own site visit, that when you get up to the Bielach and when you look towards Mount Battock, what is very evident to the eye, is the evidence of shooting activity. There's a large hut, or building, which is used for shooting lunches and that sort of thing. And then there is a smaller building, which is an older one, I think is disused, and there's quite a big hard standing for parking for vehicles.
Is that on the Glendye side, the smaller building?
It's, if you look at viewpoint for Mount Battock, if you go to D1, and you go east along the ridge, which is also the visual watershed for Glendye Windfarm, and you'll see on D1 there's a small Roman 3.
I'm not there yet.
Okay.
Oh, D1, I thought you were referring to the visual.
No, that's okay.
Classic. Right, sorry, start again, please.
Okay, that's no problem. You've got viewpoint for Mount Battock.
Yes.
If you come along the ridge line,
East or west?
To the east.
Yes.
Which is also the visual watershed for Glendye. You can see there the ZTV. There's a figure 3, Roman 3.
Yes.
And just to the east of that, one each side of the ridge line, there are 2 buildings relating to shooting activity, and there is a hard standing for parking, and that is in the area of the Bielak that you were describing.
Yes, no, sorry, I do remember them. I thought you were meaning further south into Glendye itself,
No,
into
no,
the Bielak.
that's okay.
No,
Don't
that's
worry.
good.
It's
Yes.
me not putting the question clearly. Glendye is, of course, a much overused word, but it's true in this case, is an upland bowl. I know that that's an issue between us in terms of visual effects of the development, because you say that the hills which create the bowl are those which you want to protect. I understand that argument. This question is not about that argument. But if you look at the wilderness maps, whichever you look at, whether it's F5 in Sam Oxley's series or F4 in your series, can I suggest that one of the reasons, I'm not saying it's the only reason, but one of the reasons you get that green tinge is because of the bowl, that you don't get the visibility out of the bowl towards the man-made artefacts outside.
Well, yes, and I think that heightens its remoteness. Therefore, it's increased wildness character.
No, that's not quite what I said. That whether you feel more remote or otherwise is another matter. The reason for the mapping green area is, at least in part, maybe in whole, I can't tell because I haven't got the technical detail in front of me, because of the bowl effect which shields Glendye when you're standing there from visibility of what is happening outside the bowl. That's a function of the mapping exercise.
Yes, that's correct.
That's correct, yes. Indeed, if we go to CD 946, which, with apologies, is not a document I notified in advance. Oh, wait.
And CD 956.
946. I'll wait while you get it, and I didn't notify it in advance.
Oh, yes, sorry, I do have that document out. Apologies.
Are we there?
Yes, I am.
Okay. We can see that, for example, in relation on page 3 of 14, small Roman 3, remoteness from public mechanised access, that sorry, I've got the wrong reference there. It's not. It's next one, paragraph 4 on page 4 of 14, lack of built modern artefacts, that what the mapping does is to create theoretical visibility of buildings and structures, such as roads.
Yes, that's the, as I understand it, the voxel tool.
Yeah. So that if you are in a bowl in the landscape, and I appreciate there are other layers to be applied, that green tinge may come about precisely because of the factor which I mentioned, that you can't get visibility of what's outside.
Yes.
Yes. Effectively, looking at it in a rather lay terms, the exercise really is a ZTV of modern influences.
Perhaps more basic, but yes, that's my understanding of it too.
Yeah, precisely so. Nor, of course, does the mapping take into account the experiences en route to Glendye. In other words, if you are walking from the north, from Mount Baddock, you're coming from the north, any direction, frankly, coming up the access track for that matter, the colour that is applied to Glendye does not reflect the visual experience of the person walking up those tracks or coming from outside. It reflects the experience inside the area of Glendye only.
Well, this doesn't reflect experience, this just maps character and wildness character and scores. So experience is not part of this. That has to be assessed separately.
Absolutely. It's a matter of field work.
Yes.
So that these maps are very much a starting point.
Yes, they're a data
You
set.
then need to apply field work.
Yes, and that's very clear in our wildness map
Yeah.
and our guidance, yes.
Well, it is, but of course, yesterday in Chief and elsewhere in this inquiry, we've heard these maps used simply to indicate wildness, but that's only part of the story. You need to do the field work.
I agree.
And with due deference to Mr. Kelly, who keeps making this point inquiry after inquiry, and he's got it right for once, that the map is dated 2014.
Yeah, and I think to establish that point, I was actually looking at the existing mid-hill development, which is
Could you wait till I've answered my question?
Okay, apologies.
Thank you. Yeah. The map is dated 2014. It hasn't been repeated since, has it? That's
correct, yes.
Right. So what we're looking at reflects what was mapped, I think, at the latest in February 2014,
yes,
on the basis of CD 946.
That's correct, yes.
So, for example, and I think you were going there and got there before me, it does not take account of Mid-Hill Windfarm.
Well, it takes account of part of Mid-Hill Windfarm, the original development, but the extension that goes closer to Caerloch isn't taken apart.
It doesn't take account of that. And indeed, doesn't it take account of anything else that may have happened since 2014? I'm not saying anything has happened, but it wouldn't.
No, it wouldn't.
Okay. And of course, we also know from paragraph 16 of 946, if we go there, that not all tracks, paragraph 16, not all tracks are recorded.
No, they would be at a point in time from 2014.
Well, no. Even in 2014, not all the tracks that exist were recorded on the mapping. That's what it says. Paragraph 16. There's a limitation with the data, is that not all tracks are recorded within the OS master map or the ITN data sets.
Yes, that's using the best available data we had at that time. So.
Exactly. And we don't know, in the evidence before this inquiry, which of the tracks were actually on the master map or the ITN base.
No.
No. Well, drawing those threads together, and there's a limit to which I can pursue this in the inquiry room as opposed to standing on the site, and as always, that are we agreed that the reportage should be wary of simply using the mapping data, that actually of more importance is their field experience?
Yeah, I mean, and that's very much tantamount in our guidance. That it's a starting point.
Yeah, precisely so. Right, well, I won't take that further as to what I think they will see. I'll let them see it for themselves. Thank you. Those are the questions on wildness. We've dealt with Clacnaban enough, I think, but I have one more question, I think, that are we agreed that there are no views available of the turbines in the visual context of the scarp of the Highland Boundary Fault, except from the higher land around Tullow Wind Farm, and that is the viewpoint 16 area?
No, I disagree. From Hill of Wirren, which is viewpoint 10, we can go to that, but I can just discuss it now if you like.
No, let's go there.
Okay.
Let's go there. That's fine.
Because that's to the north of the scarp, yeah?
Yes, I know. That's good enough, isn't it?
Great, thanks, Chair.
Or do you want to go to another part of it?
I think... Have you got the documents? Yeah.
Are you looking at...
I'm looking at, first
figure
of all...
620A.
If we look at the map, the sort of more detailed ZTV on figure 6.20, the first part of it.
Sorry.
Yeah,
I got it.
Yeah.
Okay. We're looking at different volumes, but I'm with you now.
Yeah.
Yep, carry on.
It's just to explain that Hill of Wirren is a core bit, I understand, but typically you have to, obviously, incumbent in GLBIs, these are representative viewpoints of wider visibility, so that you can see there that there's visibility to West Wirren and in particular to East Wirren. And typically on the sort of advertised routes for this, people usually walk up and do a sort of looped walk that encompasses both Hill of Wirren and East Wirren. And obviously, Hill of Wirren, if we then flick over to the next page, and, if and this is figure 10, 620A.
Yes.
And if you, towards the left-hand side, right-hand side of the view, just beyond the sort of fence posts there, that's the scarp slope of the Highland boundary fault appearing. And the further round you get to East Wirren, you see that far clearer. You're almost sitting on the edge of the Highland boundary fault. And therefore, the view back to the Windfarm will be the shoulder of hills. You'll see the scarp slope of the Highland boundary fault, and you'll see the Windfarm running up to that shoulder of hills. So you'll see the two in juxtaposition.
You see it in juxtaposition. Can I suggest that you're not looking so much at this, you're looking along the line of the boundary fault there?
Yeah, which actually gives you a very...
Wait till I finish the question, please. You're looking along the line of the boundary fault, as opposed to looking at the scarp feature. That's my
you're
suggestion.
looking at the scarp feature along the Highland boundary fault. You're actually there. You're almost looking at that lowland-upland divide along it. So you're actually getting a very clear, strong representation of that Highland boundary fault and that clear division between lowland and upland.
Okay. We'll have to disagree. I'll leave that to the reporters, but we say that you're not so much looking at the scarp there, you're looking along the line of the Highland boundary fault, and that's rather different from the perspective you get from the area of viewpoint 16, where you're very clearly looking at the geological and the landscape feature of the Highland boundary fault. Yeah,
no, I agree. You're not looking at it, you're looking along it, but you can still appreciate that scarp slope, the lowland and the highland.
Okay, have your answer. Thanks for that. But otherwise, whether or not that evidence is accepted by the reporters at viewpoint, the area of viewpoint 10 and the area of viewpoint 16, you don't claim there are any other views of the Glendye turbines which, if you like, are on or just above the scarp?
Looking from the south to north at the scarp slope, no, I agree, we're limited.
And in your evidence, to be fair to that evidence, also you would include viewpoint 10 looking along, but you say you also are aware of the scarp from that direction.
Yes, yes.
All right, that's fine. I don't think we need to go to viewpoint 16 because we've been there enough and we can visualise what it looks like. But at a distance, I think, of around 15 kilometres from the turbines, in fact, looking at your own summary of in 15.4.2, you say low magnitude and not significant.
Sorry, I've just got the table, but I think that's correct.
High sensitivity, visitors to the roadside viewpoint. Low magnitude, not significant.
16. Yes, that's correct.
Okay, thanks for that. If you go to your inquiry report at 5.9, and the...
Oh, hang on, I'm not there yet. Sorry. I'm using the manual version.
It's on page 18 of your inquiry report.
Yes.
And the topic here is the Highland Boundary Fault. And I'm not going to go back into the general topic, but I want to note what you say on the second page of 5.9, i.e. page 19, about other wind farms, Mull Hill, Mackrich, Dullater and Nathrow.
Yes.
Now, Mull Hill I'm sadly familiar with, and that quite clearly is rejected very much because of impacts on the Highland Boundary Fault. I accept that. But you'll be familiar with that site, I'm sure, and the Mull Hill turbines would have been on or just above the Highland Boundary Fault, as viewed from the area of Cymru, Crieff and Strath.
Yeah, I'm not, I wasn't the landscape advisor for that, but I'm aware of the case, and that broadly summarises it, yes.
Okay. And if we go on to Mackerich, the issue, I believe, there was actually the National Park. It wasn't the Highland Boundary Fault.
Well, it started out as a Highland Boundary Fault, and then they dropped one of the groups that was close to the Highland Boundary Fault, but then it became the park. But by virtue of that, the impacts were on the likes of Driesch and Mayer, which are two of the key hills on the park, and I would argue that this is a very similar case in that those were nationally important hills or mountains that are being affected by Mackerich, and these are regionally important hills that are being affected by Glendye.
So is traffic going by there? I think I heard you right. Looking at the letter 1626, I'll read it, there's no need to go there. Others may wish to. This is the SNH objection to Mackerich. SNH, page 1 of the 1626, objects to Mackerich due to significant adverse effects on the Cairngorms National Park. And I'm looking through the letter, which is the public-facing evidence of why you objected, whatever you say now. And I'm not sure there's a... I'm just checking it carefully. No, I'm pretty sure it's all about the national park, isn't it?
I was the landscape advisor for that, and we had a lot of pre-scoping, post-scoping, consultation, iterative design, which Nature Scott was involved in. And we, whilst we raised a number of issues, Highland Boundary Fault included, and they were able to mitigate the Highland Boundary Fault effects, but not the national park effects.
Oh, well, that's fair enough. I accept that answer. So, although you record Mackerich in this paragraph in your inquiry report, ultimately the issue was not the Highland Boundary Fault, it was the park.
Yes, and as I explained, I think it's a very similar case in terms of the effects on two of the hills or two of the mountains within the national park were Driesch and Mayer, and the relationship of the landscape character types to the park is very similar to here in Glendye.
Well, hold on. In evidence before this inquiry, you've put in 1626, and the only other evidence we have is your inquiry report at 5.9. And it's quite clear from this letter that SNH, whatever may have been going on in the background, which is not before this inquiry, and the scoping reports and the email exchanges, the issue was the Cairngorms National Park in terms of the objection. Okay. Turning to Nathro, I'm sure that was about the Highland Boundary Fault, but the fact is that application was withdrawn, wasn't it?
That's correct, yes.
It was never determined, and therefore the issue was never tested.
That's correct, yes.
And Dullater, I'm treading on Mr. Finley's private grief here, was... very public grief. Well, I'm sorry about that. That was rejected partly because of the Highland Boundary Fault, but also the River Tay NSA. Those are the two.
As I understand it, yes, I wasn't directly involved.
All right, that's fine. Thank you very much. I'd like you to get out, please. Now I'm changing topics to the Canamount Road. It's my penultimate topic. If you go to, if we can get out viewpoint 6. And actually 7 to begin with. 7. What I want to do is to drive up and down that road. So we'll go south first of all. And if you also have inquiry map D1 in front of you to give us the theoretical visibility. Let's just track that visibility first of all. As you come up from Glendye Lodge and the car park to Clacnaban, and you drive south, you come into an area of theoretical visibility north of viewpoint 7. You then, I'm just going in general terms before I go to the viewpoints. Sorry, are you looking for something?
Yeah, no, I'm just going to get one other thing out in front of me.
I don't want to.
No, you're...
I'll wait until you're ready.
Right, sorry,
Okay.
please carry on.
Looking at D1, coming south from Glendye Lodge, you see an area of theoretical visibility of some of the turbines, and then you get more of the turbines as you get to viewpoint 7. You enter a woodland, it drops off, and then you reacquire visibility coming towards viewpoint 6. Not of all the turbines, but I think 8 of them from memory from viewpoint 6, about that. And then you drive north a bit, and then you lose visibility for a bit, reacquire it at Cuckram, and then you maintain visibility all the way to viewpoint 3. So that's a stretch of the road. That's a general overall experience of visibility, isn't it?
That's correct, yes.
Okay. Now, looking at viewpoint 7, which I'm looking at within CD15 at figure 617. I think 617A, the wireframe, will do us, unless you want to go elsewhere. But this is viewpoint 7, and we see the road after. We can see that you can see the turbines. Yes, there is a degree of screening, but those are not, I think, commercial forestry trees, are they? Those are.
They don't look like that. There's more variety to them.
Yeah.
Than commercial forestry.
So unlikely to be felled in the same way as a coop of commercial forestry would be.
I can't comment on that's typical of commercial forestry, but I don't know with respect to this area what the proposals are.
Visibility. And then the road turns left, and that's the point we just rehearsed at which you start to lose visibility until you reacquire it before viewpoint 6. Is that right?
Yes, that's correct.
And I think both parties, let me just check. There's a disagreement between you and Sam Oxley on the significance of effects at that viewpoint, I think.
Yes, there is.
Yeah, okay, fair enough. I'm not going to question you on who's right. Then you drive south to viewpoint 6. And I suggest that as you really, almost as you leave viewpoint 6, and D1 will tell us, that views of Clackner Ben become more and more behind you, don't they?
From viewpoint 6, they're already behind you to Clackner Ben.
At the viewpoint 7, they're behind you already.
Yes.
So what we're focusing on here is not so much Clackner Ben, but the experience of driving south. And you've described that experience of the anticipation of arrival at viewpoint 3. We have that in your evidence. Okay. I think also as you go out the road, there will be intermittent visibility of mid-hill, won't there?
Yes, there will be more so from the south. Less so from there because typically the landform to the sorry, I'm looking at this map upside down. So more so to the landform to the east when you're driving round. You're almost sort of driving round a curve of upland landform. So actually your views to Mid-Hill, you don't see Mid-Hill from this area because you're actually very closely tied into the landform. So you're within the forestry, you're actually typically looking ahead or you're looking towards the west and round. And as you come out to viewpoint 6...
Sorry, you said to the left. I think you...
Sorry. I should have it written on my hands, sorry.
I think, to be fair to your case, you'll say you're looking to the right.
If you're travelling south,
Yeah.
views east are typically screened by landform.
Yeah.
Views west are typically more opened out. You're coming round into viewpoint 6. The landform is very close to you on the east. You're getting a view towards the landform, but the moorland rises up. and views west immediately beyond the edge of the forestry open out and are directly down and along Glendye.
Okay. I don't think we dispute that you'll be more aware of Glendye than at Mid Hill driving south. That's not in dispute.
Yeah.
I'm really painting a picture here for the reporters for their site visit, not seeking to persuade you of anything.
No, I think it's just more that Mid Hill, from those points, there's no experience of visibility.
All right. So, and then I don't think I need to drive you up the road to viewpoint 3. From that moment onwards, we know what we see and we know your evidence. We have Sam Oxley's evidence. Driving north, though, on the B974, you crest the hill at viewpoint 3 and suddenly you get visibility, and indeed that experience is one you describe. But equally, I suggest that from there, Mid Hill is pretty obvious off to the right.
You do see Mid Hill to the right, and I'm not disputing that. I just think it's viewed in a different context. You're viewing it looking eastwards. It sits within forestry, but you do see it.
Yes, looking at the driving experience of this road, which you regard as important, as a matter of fact, never mind the landscape context, I'm an ordinary visitor driving my car up the road. You're going to see Mid Hill clearly off to the right, aren't you?
Yes.
And in front of you. Off to the right in front.
Off to the right, obliquely
Yeah.
to the right, yes.
Fairly obvious. Whereas Glendye, almost from the word go, yes, it's close, but yes, it's oblique. It's a very oblique view to the left.
I disagree. You crest up onto the hill. You see, first of all, Clachneben, and then once you get beyond that car park, which is a matter of seconds, views open. You're looking west. You get up onto the crest of the hill. You look on the crest of Cairnamount. You see Clachneben, and your view opens out to the west. And directly there, you see long-distance views along and into the Cairngorms National Park. You see Loch Nagar clearly, and that's where Glendye would sit.
Well, at least I'll put to you our evidence so the reporters have a note. As you drive north, Mid Hill is much the more obvious Windfarm, that actually off to the left, A, it's oblique, and B, it's intermittent, the views of Glendye.
I disagree. I think you see Mid Hill first when you're driving up onto that top, but views open out west. And I think, given the context of Glendye, sitting in front of distant views into the Cairngorms National Park will substantially raise its level of effect.
Okay. A final topic. Getting on very well. It's just we have very little from you on design because obviously your evidence is locational rather than the layout. But if we go to paragraph 818 of your inquiry report, you deal there on page 43 with skylining. Given the prominence of skylines, it's particularly important that Windfarm avoids these. This is in siting and design, isn't it? That's where
That's correct, yes.
advice comes from, yeah. And then in 820, I had a slight chuckle when I read this. I thought, well, where are you going? Because then you're talking about backclothing.
Yes,
And
and
that's
I think
also
that's clearly set out. Sorry, pardon me.
Undesirable. If you go to 823 and 824, I think you're wrestling with yourself there in terms of trying to strike the balance between skylining and backclothing.
No, I'm not wrestling with myself. I'm explaining that we're not trying to, we're being rational and proportional in our guidance, that we recognise that there is this tension between skylining and backclothing. And so we're not necessarily offering that everything should be skylined or backclothed. It has to be, the guidance has to be applied relevant to the site and the development in question. And in a lot of the assessments of viewpoints, backclothing was seen as a positive way of mitigation, or a way of mitigating a lot of the development. And I'm just putting forward an alternative thought to that, that actually backclothing in upland landscapes where you're looking across a development with a darker backcloth and lighter turbines doesn't necessarily mitigate those effects. It's an alternative opinion. I'm not suggesting one or other is greater or lesser. It just raises that backclothing isn't always necessarily a good form of mitigation.
But for all commercial wind farms anywhere in Scotland, you're going to get a mixture of backclothing and skylining. It's a balance which you're never going to be able to resolve.
Well, I disagree. I think in some contexts the wind farm might be more skylining and or more backclothing, and you have to make that judgment here. The nature of this development sitting at a low level and the amount of hills running around it, you actually get that constant change of mix of backclothing, skylining, backclothing, skylining.
Well, yes.
Therefore, you can't get a consistent level of mitigation using either skylining or backclothing.
I think you're pursuing nirvana, aren't you? You're never going to achieve that balance.
Well, maybe it's the wrong site then.
All right, and of course, what you see and how you perceive the colour of the turbines depends not only on backclothing or skyline, but on the time of day and the weather.
Correct, yes.
Yeah, okay.
But I would argue that that's in relation to skylining. You're likely to more get a consistent backdrop with a landform than the sky, because sky will change.
Okay. Ms Fletcher, thank you very much. Those are my questions.
Thank you.
Thank you very much. Neither of the reporters have any questions for the witness. Thank you. But I'll hand over to Mr Finlay for re-examination.
Don't get away yet. If I can take you back to yesterday afternoon, there was a discussion between you and Mr Trenick about landscape character types and landscape character areas. And in the past, Aberdeenshire was the beneficiary of both. You had a landscape character type which was subdivided into landscape character areas.
That's correct.
But am I right in understanding your answer that landscape character areas in Aberdeenshire are now superseded?
Yes. It's a type that extends across into Aberdeenshire, yes.
So that the 2019, I think it was, exercise.
Yes.
For Aberdeenshire, we know that the site falls within LCT 29.
Yeah.
Are there any LCAs anymore in which the site falls?
No.
No. Thank you. You were then put to you and agreed that Nature Scott, then SNH, didn't object to Fetteresso or Mid Hill.
That's correct, yes.
Do you see that as inconsistent with your objection in respect of Glendye?
No, I think it's very consistent in terms of our approach to wind energy development, in particular to this area. We see that the context of that landscape was different. We felt that I wasn't involved in the original Mid Hill, but we felt that was it doesn't raise any issues of national interest to it. It doesn't have effects. But Mid Hill sits on a very different landscape where the clear expression of the Highland boundary fault is far less. It fades away, I think the term is being used. And Mid Hill doesn't sort of raise the same levels of issues as Glendye.
Thank you. Then you were a number of questions were put to you as to how the poor developer was to know what your concern was.
Yes.
And I'm afraid this touch of re-examination is going to take a little bit of time. And I think Mr Trenick touched on it this morning, what is the purpose of drafting your formal objection?
Well, I don't draft an objection. I draft landscape advice that informs the objection.
So yes, but what, in terms of Nature Scott's approach, what if you're looking to see what your objection is, where should you look? Should you look to your advice?
You look to the objection letter.
So let's go and have, because I don't think we're taking to it anyway at length. It's 233, CD 233.
Yes.
And the summary in paragraph 1 talks about under landscape and visual impacts, the proposed wind farm would have a significant adverse effect on the eastern part of the Mount landscape. And then there's a description.
Sorry, I'm finding that a bit distracting.
Sorry. Yeah. I think you're just in her eye line, which is probably what's more distracting than the noise.
Thank you.
So I'm not going to read it all out, but one can see a summary of on the first page of the letter.
That's correct.
And then there's talks about the narrow upland of the eastern Mount.
Yes.
But if one goes to, and it's the way all Nature Scott objections or impacts are set out, you go to appraisal of impacts in section 2, and there's a description of the Mount.
That's correct.
Which is entirely consistent with the description that you gave yesterday morning, not surprisingly, taken from the Tayside Landscape Character Assessment. And so we know that in this document, certainly what the author means by the Mount.
Yes. Sorry, I'll let you continue.
No.
Sorry, James.
And then over the page, there's a description of the eastern Mount.
Yes.
And I'm not going to ask you to, again, read that out in detail, but is that broadly consistent with the area that you've highlighted on the plan that is attached to your report?
That's correct, yes.
Okay. I'm not going to go through that in detail, but so we can put 233 away. That's the document that should be looked at to understand your objection. In your first description of that area, I think was identified yesterday in the report in the response to the scoping exercise, which is CD 1610. It may also be 245.
Yes.
But I'm going to look at it CD 1610. And did you draft this letter, or is this informed by your advice?
It's informed by my advice.
And there's a description of the Mount and a description of the landscape of the area that you're particularly concerned with.
Yes.
There was a plan, we needn't turn it up, your sketch plan.
Yes.
Which I think is maybe page 41 of CD 245. Do you see any difference between what's set out in that sketch plan and the written description here?
No.
And then this is then sent in response to scoping. Did at any stage anyone come back and ask you, what on earth are you, Ms. Fletcher, or you, SNH, talking about?
No, and I think that I was reflecting on this further, and I think that's a key aspect. As I mentioned with McCritch, there was a lot of pre-scoping, post-scoping design iteration, which we would normally engage with developers at that nature. And in fact, that whole approach is set out in GLVIA on page 29. And there's a figure 3.1. And it just, in a very sort of simple flow diagram, there's a series of sections, and you have screening, scoping, establishing the baseline, identifying and describing effects. And all the way down the side, you have a bar with consultation, and those arrows inform it at those stages. Beyond scoping, apart from agreeing viewpoints, there was no further requests for clarification of any advice we gave, even though actually at the end of both letters it does say, if you want to contact us, please do so, and they gave a contact name.
Then, just to pick up, as you say, there was further correspondence and interaction before the application was formally put in, and I think CD 1611 is a response by SNH to the consent unit. It's a gate check report.
Yes.
Again, making the point under landscape and visual, and making, in more summary form, the comment on the impact on the Mount landscape.
Yes.
And then I just want to ask you to turn now to CD 1.3, which is the EIS, to see how that's picked up in the chapter which deals with the EIA, approach to EIA, which deals with the scoping responses. That's chapter 2. And if you have table 2.1.
Yes, sorry, I've got that.
And SNH are the second entry on table,
Sorry.
on the table.
Yes.
And under the first heading, it's the introduction of 40 wind turbines up to 150 metres to blade tip could result in significant adverse impact on the regional distinctiveness of the area, resulting in a potential objection to the proposal.
That's correct.
There's mention of the southern flank has a high degree of visual sensitivity, and then the EIA should consider the recognisable landscape character of the mount, which contributes to the reasonable regional distinctiveness of this area of Aberdeenshire. In your view, is that a reasonable summary of your concerns as set out in the response to scoping?
Yes.
And we can see what the response and action taken there too. I'm not going to ask you about that. I can comment on that in closing. One of the, just whilst we're here, one of the further points that was made in your response to scoping was about site access, and that is picked up in the fourth entry on that column.
Yes.
One can see again what the response to that is. And I'm not going to ask you further about that. So we have your scoping response, we have the gate check correspondence, we have that. Even when, I think Ms Oxley, I think it's clear from the scoping advice which is included in Nature Scots Productions, that LUC got involved shortly after scoping was carried out. Mm-hmm. Did LUC come back and ask about your concern about regional distinctiveness at any stage?
No, they didn't.
And then finally, I think without needing to go to them, although we can do if you'd wish to do so, Mr Trinick pointed out that the final emanation of the area covered by, that you say is covered by the Eastern Mount in your report, which mm-hmm. I think is figure 3 or 4, is clearly different in some aspects mm-hmm. from the initial sketch plan.
Yes.
Now, you can go to them if you want to, but you may be able to recall, is the southern boundary, or the boundary that runs south, west, north-east?
Yes.
Is that, has that changed at all in any materials?
Yes, it's actually pulled in through further field work, looking at that particular area, which I did quite extensive field work down in the area. I pulled it in further because I felt that up to Ben Turin, actually, once you're on Ben Turin, the landscape starts to flatten out, plateau out, which actually has a very different landform to the distinctiveness, the more rolling, distinctive landform of the Eastern Mount area. So I actually pulled that boundary in to reflect that.
So you pulled it away from Ben Turin?
That's correct, yes.
And how far is Ben Turin away from the site, broadly? It's a very useful plan, but it's difficult to manage.
It's approximately, sorry.
I think it's winning at the moment.
Yes, it is. I'm going to just go straight to the
If
viewpoint.
it helps, if you go to Sarah Fletcher's figure 3 in her appendices, you'll find it without wrestling.
Right. Okay. Very grateful.
Now I've got to find that appendix.
I can
Ben Turin, yes, it's about 20 kilometres, very approximately, using my pencil as a marker.
So that's that boundary you've drawn in through fieldwork.
Yes.
The boundary that demarcates the extent effectively where the Highland boundary fault line runs, has that changed significantly or at all?
No, no.
The boundary that broadly follows the Cairnmount Road that you've just been discussing with Mr. Trinick, does that change to
No.
any significant extent? No. I think it's pulled back a bit further from the park at
the north
side.
yes, yes.
And again, why did you do that?
Through further field work from visiting the Cairloch area, and in that region you get a very, whilst it's on the sort of lower slopes and you don't have that, it doesn't sort of represent the more upland, moorland character. It's got a greater extent of commercial forestry, and it has a lower slopes, the experience of the roads, and some steadings, etc., in that area that reflect different character.
But in terms of the refinements that you've made, how significant, in your view, are the refinements that you've made?
I think the refinements actually identify a stronger core to that experience of expression of the key characteristics that I've identified in my appendix 2 at the end. I identified 15 key characteristics relating to the Eastern Mount, and this area captures those key characteristics.
I'm grateful. We can move off that topic. You were asked towards the end of cross-examination yesterday that if you could carry out the intellectual exercise of forgetting about your regional issue, would this be a good site? And you gave your answer to that. That was about the site itself. What's your view about the access over the Highland boundary fault? How would that impinge upon your answers to whether this is a good site, leaving aside the regional distinctiveness point of the Eastern Mount?
In relation to our upland tracks in the Scottish landscape, I think that very strong form of line appears contrary to that guidance, where it's actually sitting at odds with the existing scarp slope that runs down. It creates a very, by nature of the technical requirements of Windfarm roads, they have a very uniform gradient. And whilst there are other tracks on that scarp slope, they are typically hugging the landscape and they pick up local landform, whereas this is a very uniform line.
Thank you. We can move off to this morning to the subject of wildness and wildland mapping. And it may be helpful just to have in mind, if not have to hand, Miss Oxley's wildland mapping exercise. She's produced all 5 maps. I think you've just produced effectively the 5th, which is the relative wildness one.
That's correct, yes.
You agreed, I think, with my learned friend that in respect of map 4, which is lack of built modern artefacts, that's essentially a ZTV of modern artefacts. So if you're in a bowl, you're likely to score lowly.
Yes.
But the relative wildness map is not just a combination of map 4, it's maps 1 to 4.
Yes, that's correct.
And the first one is perceived naturalness, the second is ruggedness and challenging terrain, which you commented upon, and the third is remoteness from public mechanised access. Are they affected by being in a bowl as such? In terms of visual influence? I mean, the ruggedness may be affected by being in a bowl because you'll have the sides to the bowl. There are some cases when bowls are more like saucers, but this bowl is a bowl, I think. But in general terms, the point about the ZTV, does that apply to the other 3 mapping exercises?
The Vauxhall information isn't, no.
Sorry?
It's not used for the other 3.
Great, thank you. And also, Mr. Trinick made a point about the maps on a Scotland-wide basis. The guidance says that not all tracks are caught.
That's correct, yes.
But in your experience, clearly extensive experience of crisscrossing this land, are the tracks shown on the Ordnance Survey maps that you no doubt use to navigate around? Have you come across tracks that aren't on the Ordnance Survey maps?
I think there's maybe 1 or 2, certainly from Glenesk in particular. But I think in broad terms, that's a very clear indication that there are far more tracks coming off of Glenesk than there are coming off of Glendye.
Thank you. Very much on the home straight. You were asked a point about viewpoint 7 and whether the forestry is commercial forestry or not, which and might have been a point better put to Mr. Steele. I'm not taking a point on it, but because he deals with viewpoint 7 in a lot greater deal than you do. But, ma'am, I'm just raising that, and sir, just raising that point at this stage to ask you to note in your site visit, because I think Mr. Steele relies on it being commercial forestry from viewpoint 7, like to come down. We're not asking you to undertake an accompanied site visit, but you could either stop at viewpoint 6 and walk back, or there's a forest track entrance slightly further down the hill. You could park in and walk up to viewpoint 7. I think stopping at viewpoint 7 itself might be a bit dangerous. And lastly, you were taking on the journey up and over the Cairn Mount from north and south.
Yes.
And Mr. Trinick was putting to, I think when coming from the south, heading north, he put to the point, as you come over the top, suddenly yes. there will be Glendye Windfarm, if it's permitted. I think his use of the word suddenly. There is guidance from SNH about first views
yes.
being important. And in the context of that sudden apparition of Glendye, and as I think you put seconds after you've seen Clacmaben, how does that relate to the guidance on importance of first views?
I think this, in relation to, first of all, the scenic characteristics of that route and the experience for a lot of people of that upland landscape, this development substantially falls, is contrary to that piece of guidance in our report. We've had quite a lot of discussions of foci and whether or not the wind farm would compete with Clacmaben and with other key views. And I think if you strip the issue of foci back to its very basic, if you have one key foci in a landscape, your eye will be drawn to it. If you start introducing other foci into that landscape, irrespective at this point of whether or not they are very different in character, the same, your eye will naturally be drawn to different foci, thereby mean that you will, your attention will be taken away from the original foci. Now, if you have a very natural feature, which Clacmaben is, the Tor is a natural feature, by virtue of introducing a large spread of 149.9 metre rotating turbines, it's my understanding and my belief that that would significantly detract from the existing foci, irrespective of whether or not it is sitting in front, below, or to one side, or even in the opposing direction.
And sorry, I omitted to ask you one point. We don't need to go there, but you went to viewpoint 10, and there was this morning, and there was a slight debate about the relative importance of looking along the HBF from viewpoint 10 as opposed to looking at it from, I'm going to say viewpoint
16.
16, yes. One can obviously understand, I think, Mr. Trinick's point that the HBF can be, to some extent, best appreciated from the lowlands looking up to it.
Yes.
Because you see the flat Braes of Mearn in this case, and then the Scarp Slope. But is that the limitation from appreciating the HBF? Can you, the appreciation, is it possible to gain appreciation looking along it and or even down to it from the upland area.
Yes, definitely. And I think, interestingly, Hill of Warren is a viewpoint that not only picks up the scarp slope, but interestingly, it's a viewpoint where you appreciate the flow of the existing special landscape areas. So you appreciate the braes of the Marne landscape coming up onto that shoulder of hills, and then you appreciate the that by abutting against the Clachneben SLA. So it's actually one of the few locations that you get that flow between one SLA and the other by virtue of the fact that you're joined. And introducing the development into that view would effectively fragment that view between one and another. Now, I'm sort of maybe encroaching into my colleagues' evidence, but, you know, you have to remember that people will experience these special landscape areas in reality in the site, and I think Hill of Warren is quite an important viewpoint from that perspective, that you actually, that Windfarm will fragment that experience between one SLA and the other.
And talking about boundaries of SLA, viewpoint 3 is on the boundary between the SLAs.
Yes.
I think we're going well beyond re-examination now. I didn't ask any questions about that. Come on.
Well, no. I'm just. I'm coming to the Highland boundary fault line. I'm not asking about SLAs, so I'm afraid you jumped in slightly too early.
Sorry.
No. It's Mr. Trinick I'm saying has jumped in too early. Do you get that appreciation of the looking up and down at all from the Highland boundary fault line you get from viewpoint 10 at viewpoint 3? Yes,
you do. I think, to use, again, my colleague's term, it's a bit more of a compound fracture from that viewpoint, but you very much experience that upland-lowland divide.
Yes, thank you very much.
Thank you.
Just before we depart, there are a couple of factual points, and I'm not criticising any questions asked, but when Sarah Fletcher was talking about the mapping of the eastern mounts, we may have misheard. I'd called a stray reference to some other map defining the eastern mount.
Maps, as far as I'm aware. There's the initial sketch map, which has what looks like a felt-tip boundary on it. And then there's the map that's more formally produced for the purpose of the inquiry in Ms. Fletcher's.
That clarifies that. The other point is just about LCAs. Now, clearly, the 2019 Scottish Landscape Character Assessment did what it did, but LCAs have been mapped for the purposes of this inquiry and have been discussed. That part of CD 932, which contains the text of the document, is not before this inquiry. It's not in my bundle anyway. But although you say in 612 that Mount LCA became the LCT 20, whatever it is, 22, my understanding was that the LCAs are not being withdrawn.
It's a matter of agreement that they've been one in, I think it's 518 and 519, the Statement of Agreed Matters, that the 1998 character assessment has been superseded by the 2019 character assessment.
That's correct. This, by virtue, this is a sort of crossover development from pre and post. So we didn't want to be as hardline as saying, no, we all have to move to the 2019, because I think that's very impractical and disproportionate. But you have to take cognizance that we do have this data set.
And just so, Mr. Trent, I'm not suggesting that evidence given by reference to the landscape character assessment areas or the landscape character areas is irrelevant, because one can see how it can tie in, and it ties in with the EIAR. So I echo the answer that Ms. Fletcher has just given, that we're not being categoric about it, but in technical terms, one has superseded the other, as my understanding.
Well, I still understand that, but also we do have the SLCA, the Strategic Landscape Capacity Assessment, which is still a live document, and which does deal with LCAs. So, okay.
It's interesting that Mr.
No one's saying
Trenick's
they've
relying on the
disappeared forever.
SLCA
Thank
and
you.
not this side.
All right, okay. Thank you.
I think that puts you out of your misery, Ms. Fletcher.
Yes, I'm not married anymore.
Sorry, no, Ms. Fletcher. No. Yes, but you're not looking very miserable. Now you've come to an end.
I'm breathing. Thank you.
Okay, so thank you very much. We can release you now. Ms. Fletcher, thank you.
Thank you.
And thanks everybody for being so well behaved and professional throughout. We have got a little bit of timetabling to discuss for the rest of the week. In the note of the pre-examination meeting and timetables that you've seen, closing remarks will be delivered in writing. So your closing arguments to that timetable. In terms of the rest of this week, we'd move that we'll have a short break now, just allow people to get, just to reconfigure the room slightly and to put out some more microphones. And we'd say that before lunch we'd like to do, if parties were open to it, to do the policy session, the policy hearing session first of all. We have got the historic environment and cultural heritage scheduled for after lunch, but depending on the progress we make, we'd hope to also get the conditions session done this afternoon as well, which would free up on our side the whole of tomorrow for site visits if we get through those sessions, and we'd be able to start at an early point and work as long as we need to on that. So we'll have plenty of flexibility. And then Friday morning we have the final session, which is the community issues, which there is some overlap on some of the matters to an extent, but there is a tighter focus on recreational users and whatnot, which is set out in the agendas that people will have seen. Is there any questions on the timetabling at this point? Mr. Kelly.
I've still my landscape and visual impact assessment evidence to give. It will be very, very, very short, but for the record, I would just like to read in the 4 points.
Sorry, Mr. Kelly, I really apologise that we forgot all about you. We had to hold our hands up and say we forgot all about you. I don't know how we could do it, because you're sitting right there in front of us. I don't know how we forgot you.
If you're happy that I do my evidence from here, I'm happy to sit here. As I say, I promise it'll be less than 5 minutes. There's only 4 points.
Well, shall we have a short break first, then we can come back to you? Is that okay?
Well, to be honest, if Mr. Kelly sticks to proof and doesn't depart and start saying other things, I've got no questions. So if he could do it now, I'd be perfectly happy. Right, okay. And then we can finish.
Okay.
Sorry about that, Mr. Kelly.
Thank you. Thank you. Thank you, sir. Morning, sir. There are only 4 points that I want to make now. You have my inquiry report and my recognition. First point, I was grateful to Mr. Trinick for raising the issue of repeat mapping of wild land areas. As he and I know, we have discussed this at several inquiries, and I note that on this occasion it might well have helped his clients to have an updated WLA map. The original methodology was specifically required to be repeatable, and I simply don't know why SNH and Nature Scott have not done that for major developments. I also think in many cases it would help the reporters to see updated maps so they can draw their own conclusions. Second point, whilst I comment on the EIAR LVIA findings, I must be quite clear that I don't pretend to be a landscape architect in approaching that evidence. Third point, as mentioned, I approach the consideration of the landscape and visual issues as a planner and a geographer. I try to understand the geographic setting of the site and how the wind farm would sit into that geographic setting. And the fourth point, flowing from all of that and as set out in my evidence, my conclusion in the recognition and inquiry report is simply that this is the wrong location for a wind farm. Thank you. They are the only 4 points that I wish to make.
Thank you very much. Apologies once again. Are there any clarification? No? And there are still no questions. Okay, thank you. Then I move we'll break between these sessions, and we'll come back in
Just one point. I know that Commander Strong wants to raise cultural heritage issues, and those he may want to raise them in the community session as opposed to the cultural heritage session. I just want to get clear that Mr. Moody, my cultural heritage witness, will not be here on Friday. So if there are to be questions raised or discussed, rather, about cultural heritage, I think they ought to be raised in the cultural heritage session and not left for the community session. Yeah, the cultural heritage questions are in the agenda for today, and they're not on the agenda for Friday. That's right. Fine, just get it clear. Okay, so thank you very much for that. And I'd move that we have a 15-minute break and come back just after 11:30, please. Yeah, we are. Yeah, if possible. Thanks. We may have a few speakers involved, so we thought we'd just leave it at the way we've got things at the moment. So it's still morning, so good morning and thanks for joining us. As participants today in the whole have either been present in the previous days. We won't go through all the housekeeping and introductories, but we've got a busy day today, so we're gonna try and get through it as fast as possible. Before we go into that, we just wanted to touch very briefly on the timetable for tomorrow, providing we get through all of the sessions today. It's, as we said earlier, it's already been agreed that that we're going to be undertaking a site visit to focus on the access track, the borough pits, and we're going to go up to the viewpoint at Mount Battock to get a feel for the site. Prior to doing that, because Commander Strawn was interested in coming along and has also made a request for a site visit, we intend to meet prior to going to the site visit in the vehicle out at the Fasque Guest House. We haven't got the definitives yet, but if we do finish things today, we'd aim to meet there at 9:30 so that we can subsequently meet at the appeal site at the application site, sorry, for the later accompanied inspection. So anybody who's attending will be more than welcome to join us at that. But we can iron out the details at the end of the day when we know how far we've got through things. So that aside, because we've got some new faces, it'd be really useful for ourselves if we could just briefly go around the room and just ask the people who are taking part in this session, which is focusing on the energy policy context, energy and planning policy context for the development. So I'll start on this side. As people know, I'm Stuart West, and this is Miss Hayward, my colleague. And I'll just maybe go this direction, please. Thanks, Marcus Trinick. I won't be playing a large part in this session. The lead in this session for the applicant will be
Simon Herriot from Savills Planning.
There are no more people taking part on this side in this session? No?
Good morning again, sir. Ian Kelly Planning Consultancy Limited, representing the adjoining estates.
Thank you.
For the council, it's James Finlay, Queen's Counsel. On my right is Elizabeth Tully, Senior Planner with the Strategic Development Delivery Team, and on her right, Ewan Brown, Advocate. And Elizabeth will be doing most of the talking, and I probably the least. But I will act as a initial fielder of questions, I think.
Okay, thank you very much. Now, because we've got considerably more mics than we've been using the last couple of sessions, if I can just remind people to press the button so that the red light goes off when they've finished talking, and that should make the audio a lot more effective. And if anybody has any problems hearing anything, just raise your hand and let us know. So, The hearing will take the form of a structured discussion. An agenda's already been circulated. Now, we'll work through the items on the agenda, and for each bullet point, we'll initially ask one party for their thoughts before we move around the room, seeking any counter views or additional information from the other participants. But before we commence, can I just check there's no questions on the process we'll be following? I think everybody's done this before. Okay, so in terms of the actual agenda itself, the first item on the agenda relates to the Renewables Energy Policy Framework. Has everybody got an agenda before them? Yep. So we're satisfied that we have all the relevant documentation to consider the area as set out within the agenda, but we would just like to give parties opportunity to comment on the matters raised by others within the hearing statements if they'd like to. So we'll start with the applicant. Do you have any comments specifically on the matters raised within their statements?
Not specifically with any statements, no. We deal with anything under AOB, but that's not specifically the energy policy context.
And the council?
No, nothing from us.
And Mr. Kelly, do you have anything in the statements?
No, sir. I'm very conscious of the amount of material that you already have, and therefore at this stage there's nothing else to add or comment on.
Okay, thank you very much, everybody. So what we propose to do then is to work through the bullet points in items 2 and 3 before parties have the opportunity to raise any other matters that are relevant, as has already been highlighted there. So for part 2, I'd suggest that the applicant offers views on the subjects first, followed by the council and then Mr. Kelly. And then by contrast, I'll ask the council for their views on item 3 first, and then we'll work in the opposite direction around the room. So if the applicant is happy with that, can I just hand over to you for bullet point 1, and we'll work our way through those?
Yep, sure. So bullet point 1 relates to the importance to be attached to the presumption in favour of sustainable development as outlined in SPP, paragraphs 28 to 35. The first thing I would say on that is that the presumption is one of the key principles of SPP. It's a guiding principle, applies to all applications, and to be assessed against the criteria in paragraph 29 of SPP. So not all of these principles will be applicable in each and every case, and therefore when you're considering them, it's a question of broad fit when considering them, all of them. Now, in the context of Section 36 applications, which is what we're dealing with here, the Scottish Ministers have confirmed that in the case when the LDP, the Local Development Plan, is out of date, 5 years old, as we have here, the LDP being 2017, that becomes a significant material consideration, and we can see that in the Minister's decision on the Glendye Windfarm, and that's core document reference 13.36. Now, what we have here is an LDP that is advancing, and I believe from the Council's hearing statements likely to be or potentially be adopted in October. So at this point in time, the LDP is out of date. By the time a decision comes along, it may well not be. So the weight to be given to the presumption may well then vary from being a material consideration, a significant material consideration at this point in time, to a material consideration. But nevertheless, it forms a relevant and central plank of any assessment. And we can look to other decisions where that has been applied by reporters and ministers, including in the Paul's Hill 2, Section 36 case, and that's CD 1312, where the reporters noted there that while that LDP was not out of date, i.e. less than 5 years old, the presumption offers additional support where it can be reasonably argued that that's the case. And in my assessment, in my hearing statement, I've gone through the paragraph 29 principles and concluded that the presumption does apply in this case.
Thank you very much. I'll just move over to the other side of the room first of all and hear your views.
Thank you, sir. I absolutely do think it's important to recognise that there is a presumption in favour of development, of sustainable development, but I think it only offers half of the story in terms of the sustainability policy. You know, like I said, there is a presumption in favour of development, but paragraph 28 is incredibly clear that this does not just give a blanket support for development where there may be benefit. There still needs to be a balance and exercise, and that comes down to the right development in the right place and not development at any cost. And I'll just respond to Mr Herriot. We do expect that the local development plan is adopted fairly shortly, within the next month or so, I think.
Could I just add to that the current plan, albeit out of date, and the future plan, as with SPP, both incorporate significant support for renewable energy. So actually the material difference of the plan being out of date or becoming a new plan coming in date is probably not going to be that significant. In other senses and other spheres it might be, but because both plans contain strong support for renewable energy anyway. And I don't wish to undermine the idea of a presumption in favour of sustainable development, but it's really included. So there is a strong presumption in favour of sustainable development in any event.
Thank you very much. Mr Kelly, do you have any views?
Sir, I've reviewed what you already have from me in writing, and to help matters progress smoothly, my view is that I'm quite happy to defer to the Council on items 2 and 3, unless you have specific questions for me. I think it will help matters go much more smoothly if I just stick with what's in writing and leave matters to the Council for 2 and 3.
Yeah, that's perfectly fine. We have the hearing statements of all parties here, and they will be taken fully into consideration along with all other representations. Thank you very much. No, and I don't have any. Oh, sorry. My colleague here has a question.
Can I just ask Mr Herriot, in relation to what you said initially about the presumption in favour of development? This is not a planning appeal, so it's not a Planning Act case. It's an Electricity Act case. What's your view on how central the presumption in favour is in Electricity Act cases?
It's a material consideration, and when my reference to the Glendye decision was, that was a Section 36 case there, and in their decision on that particular case, which is Section 36, ministers give it significant weight in terms of paragraph 33, despite the fact that being Section 36 rather than a planning application case. And the reason being that the LDP there was out of date.
I think there was, I'll be honest, a slight degree of surprise at the ministerial view of the presumption in the Glendye case. Nevertheless, it's a ministerial decision. The ministers have decided that the presumption applies in Section 36 cases, and that's where we are for the moment.
And can you point me to any other ministerial decision that does similarly, or is that the only one that you know?
No.
It's the only one you know.
It's probably just worth adding, bringing it back to the Paul's Hill decision, where the development plan was within 5 years and therefore not out of date. The reporters there said that it's still the presumption offers the additional support. So you've got a reference point there for both.
And does the Council want to say anything about that?
Yes, perhaps I can add 2 points. First, before I forget it, that the new LDP will be lodged when adopted, as you no doubt expect, and when that's adopted, we'll lodge it. But very unlikely to be any surprises because of the limited room for manoeuvre the Council has. Yes, I echo Mr Trinick's surprise in respect of Glendye. The point is that, as you've pointed out, ma'am, being an Electricity Act case, the statutory framework within which a presumption would otherwise operate within the planning system isn't there. So there's no reason why ministers and yourselves shouldn't give the presumption presumption in favour of sustainable development, whatever weight you wish to give it, and that can be great weight or not. But the whole mechanism of paragraph 33 appears to be designed to operate in a development plan in a scenario where the development plan has primacy of place. It does not have primacy of place in a Section 36 application, and therefore it's difficult to see how it can directly operate, notwithstanding what the ministers say in the Glendye decision. But for the reasons I've just sought to indicate, that is perhaps more of a technical than a practical point in terms of the application of weight.
I think we're in agreement on that point. There is one point to come back on, and that is reference to the new plan not making too much difference because C2 and broadly supportive. However, there are other policies in play than C2, and there the new plan will make a difference, and we'll come on to talk about those policies in due course.
That's great. Thank you very much. That's very helpful. So the next bullet point that we've got there then, and these are all drawn from the relevant hearing statements. So the impact of net zero greenhouse gas emissions targets on SPP paragraphs 152 to 155.
Yep, thank you. I think at the outset it's probably worth highlighting that we're dealing with slightly different issues here. The net zero emissions targets deal directly with greenhouse gas reduction. We've got net zero by 2045 with interim targets including 75% by 2030 relative to 1990 levels. The paragraphs referenced in SPP deal in the main with renewable energy generation relative to 2020 targets. So they are linked, but in terms of yardsticks, SPP is dealing with 100% renewable energy generation by 2020, which has now obviously been superseded by time, whereas the greenhouse gas emission targets are dealing with emissions reductions. They are linked, but we're dealing with different yardsticks. That's the first point. The second point, which is key to this whole debate really, is that the greenhouse gas emissions targets, they're set in statute. They're the law. 2045 net zero is the law with the interim targets. So that's a key issue to take on board when considering those paragraphs of SPP. And to that extent, the paragraphs of SPP are out of date. They deal with 2020 targets. They talk about a low carbon economy. We're now talking about achieving net zero. So the energy debate has moved on. SPP doesn't reflect that. And we're dealing with emissions rather than just renewable energy generation. So those are key headline facts I'll point out there.
Apologies for the pauses here, but I'm trying to write down. Thank you very much. I'll hand over to the other side of the room.
Thank you, sir. I recognise that Scotland does have the ambition to reduce emissions targets, reduce emissions to net zero by 2045, and that is detailed in relevant legislation, and that's all discussed in our hearing statement. But I think it's important to note that policies or mitigation techniques in order to meet these targets aren't specifically included within policy. So SPP sets out a strategy to facilitate development in order to reduce greenhouse gas emissions, and that's through the presumption in favour of sustainable development. But there's no spatial aspect to it. There's no guiding of where developments are appropriate or where they should be located. Paragraph 153 suggests infrastructure is guided to appropriate locations, and that again engages paragraph 28 and the overarching principle of the right development in the right place, not development at any cost, and that brings into it what paragraph 169 and the criteria that you've got to consider there.
Sorry, Mr. Taylor, we are having to take notes here, so you're going quite fast for us to do that.
I've been told I speak quite.
So do I. I share the same difficulty. So if you can maybe just try and slow down for us, please.
Sorry, thank you.
Could you just repeat the last reference? I had the first two paragraph references, so just the last one where you brought it back forward would be great.
So just to check, you've got the reference to paragraph 153 and paragraph 28 and the overarching principle. And what I was just concluding with is it brings back to paragraph 169 and the things that we've got to consider as being an appropriate location.
Thank you very much.
But if I can just add to that paragraph 155 already requires that the development plans should seek to ensure an area's full potential is developed. So that's already the case, giving due regard to relevant environmental and other considerations. So rather bears out the point Ms Tully's already made, that there is strong support for electricity renewable sources already, and the current guidance is that the full potential should be developed. So you can't do more than that. And the targets may become more exacting, but the full potential is already meant to be being developed within development plans.
Did you wish to come back there, Mr. Harriott?
Yes, a couple of points just in response to Ms Tully's comment about I think it was the lack of a spatial guide, maybe not quite those words, but in terms of the onshore wind, we've got the spatial framework in Table 1 of SPP, which does guide and tell decision makers where wind farms will not be acceptable, where they will be acceptable in principle, and areas of significant protection. As onshore wind is concerned, we have that locational guide, and I think we'll touch upon that under item, probably the next bullet point. But the key point is that the debate's moved on since SPP, as I've said. This is no longer a nice to have, a low carbon economy. That was an aspiration for a low carbon economy. We've got a statutory requirement. Ministers under a duty to deliver net zero by 2045. And that's why when we're looking at this aspect of SPP, it does have to be considered within the context of this legally binding target. The debate has moved on, the targets have moved on. And as far as SPP is still relevant on that particular point, it does talk about a diverse range of technologies, wind, including onshore wind, and that's developed further through MPF4, which we'll come on to shortly. But in the short term, very much onshore wind will do the heavy lifting as far as MPF4 sees.
Just add to that if you look at the sixth carbon budget, CD 1022 at page 229, the 75% reduction by 2030, a requirement, not ambition, a requirement, is regarded as extremely challenging to meet, even allowing for, quotes, stretching tailwind. If we look at the draft OWPS, yes, it's a draft, CD 1038, an additional 8 to 12 gigawatts of installed onshore wind. Well, that may change in the final version, but the message is there that a great deal more onshore wind is required to meet the greenhouse gas emissions reduction requirement by 2030 and indeed 2045. So I don't think, although I know that doesn't mean every project has to get consent, what does happen, the consequence of that in the planning balance, is that if you view the planning balance as a sliding scale, as a tilt point somewhere along it, we say very firmly that that tilt point has changed because of the need case dictated by law and advised by policy. It is important. It's not just a question of ambition and you've got a choice of sites. We're beyond that now. We're in a climate emergency. Thank you.
Thank you very much for that. And I also note the the extensive background that's in the hearing statement on that. So we have that before us. Thank you. So you touched then upon the onshore framework, which, as you said, has the categorisation for the different groups where wind farms won't be allowed, where there's the potential. So the first thing, I suppose, there is that SPP Table 1 sets out the different groups, and there's been some discussion that this should be considered as a Group 2 versus a Group 3 designation. So would you like to just expand on that?
Yep, sure. So Group 2s are areas of significant protection, and SPP outlines a range of factors that would benefit from significant protection. And in this case, the sole Group 2 interest is the MAT presence of carbon-rich soils and deep peat, and that's acknowledged. The important point here is that SPP says that in those Group 2 areas, the key test is ultimately whether significant effects on those Group 2 qualities can be substantially overcome by siting design or other mitigation. And in this instance, we believe we've addressed that. We've overcome those issues on the sole Group 2 interest, and therefore we've put forward the argument, which has been accepted, that this is in effect a Group 3 area, where wind farms are likely to be acceptable in principle. That is ultimately our position on that. Yet, as a starting point, Group 2, looking at the details, we've overcome it, and Group 3, and that's been accepted elsewhere, including in the Paul's Hill decision that I referred to previously. CD reference 1312, paragraph 3.2.14. And I think that's important because that then starts you on your journey assessing an application through the 169 principles, the development management criteria.
And then going to the council, have you got views on this?
Yes, thank you, sir. Mr. Herriot pointed out the site is almost completely covered by Class 1 and 2 peatland, with the exception of a small area to the north of the site. That, by definition, I would say makes the site almost wholly a Group 2 area. So Table 1 in SPP identifies that Group 2 areas do require protection, but that doesn't rule out the chance for development in these areas. It really just means that should it be demonstrated that the effects can be overcome either by siting or through mitigation measures, then it could be considered appropriate for development. The fact that effects on peatland can be overcome by way of mitigation doesn't mean that the site isn't any longer a Group 2 area. It just means that there's no impediment to development on this area. And I would pull in, the definition of Group 3 within Table 1, and that is Group 3 by definition is areas beyond Groups 1 and 2. So I would argue that this area is always a Group 2 area.
So just to be clear, you're not saying, is the council saying that it's still a Group 2 area, but that doesn't prevent development? That's basically what your point thing is, right? Okay.
Yeah, absolutely.
Are you happy with that?
I think we just have to take a look at the Paul's Hill decision that I referred to there. That clearly goes through similar decisions, similar issues with Group 2 and arrives at Group 3. I think no need to say any more on that. But I suppose just one final point on that key issue. It is worth noting that Nature Scott did withdraw its objection initially on deep peat. That's CD 5.1, and they noted that significant effects can be mitigated, and that the scale of peatland restoration that was proposed by the applicant would have biodiversity benefits beyond just that of restoring function within the peatland habitats. So I think that's important to have a look at that in 5.1.
Thank you very much. We've got that, and we've got the reference there to the Paul's Hill, so we'll definitely take that into consideration. So you did touch earlier on the draft MPF4 and the relevance of that to the assessment of this application. Would you like to expand on that?
Yep, MPF4, it's still in draft form. I think the latest estimates are to be published in the autumn at some stage. So while certain aspects of it may be subject to change, in particular parts 2 and parts 3, which contain the descriptions of national developments, for example, and the development management policies, I think that part 1, which sets out the overarching objectives, that's probably unlikely to change to any significant degree. It doesn't contain anything particularly new or anything out of left field. It sets the context for the detailed policies, and it talks about the climate emergency, it talks about the nature crisis. For example, on page 3, in part 1 of MPF4, it talks about the need to invest in reducing carbon emissions and the need to diversify and expand renewable energy generation. Page 3 also talks about the need to make significant progress on greenhouse gas reductions by 2030, and I note the emphasis on significant progress. So we clearly have to wait and see, but they are not new concepts. They have been in various energy policy documents that are referred to in my hearing statement. What might change is the minutiae of the policies in parts 2 and parts 3 in national developments.
Add to that the driving force behind the development management policies, which will ultimately appear in the final version, the driving forces are in part 1, and the twin major themes of MPF4 part 1 are very much climate change and the nature crisis. So you've got two major themes driving policies, and we can see the nature crisis issue emerging through various biodiversity documents being published by Nature Scott. As far as this site is concerned, we have overcome the peat objection, and we've closing submissions will deal with the benefits that may emerge from that. So in terms of the twin themes of MPF4, we say that both are relevant in this case, the climate emergency and the nature crisis.
And in terms of weight to be applied, how would you describe that?
Well, I'm never going to persuade a reporter to say more than little weight at this stage, because you always do. But I think that you have to divide it into two, that little weight to the development management policies, clearly. Those may change. I mean, lots of representations on them, and we expect there will be changes. So little weight to those policies, but I think greater weight, whatever that means, to part 1, which I don't think is likely to change because it represents a direction of travel of the Scottish Government, which is reflected in MPF4 but elsewhere as well.
Would the Council like to comment on that?
I think, our position is quite simple in that we think that there should be limited weight afforded to MPF4 at the moment. We acknowledge that it may be adopted or published in the autumn, and, but to that, it's still consultative in nature and it is subject to change. So I think, going beyond anything more than limited weight would be inappropriate at the moment.
Thank you very much. I suppose, as you've said, the driving forces as you described them are set in statute, and we have those driving forces before us in the statements. Those items that you've mentioned will be taken into consideration that way.
Indeed, I think there is a practical point for this inquiry which emerges from this that you might wish to discuss at some stage, and that is we not only have a new LDP coming out before your report is complete, quite likely, we've also got draft MPF4, which is the new statutory development plan for Scotland, coming out. And we'll want at some stage to discuss what we're going to do about that for this inquiry.
We'll very much look forward to that. So moving on from the national planning policy context, then we will shift our attention over towards the development plan as a material consideration, and then to the review of the local development plan. But first of all, one of the items that has been discussed through the evidence before us has been the strategic landscape capacity assessment that was 2014 that we've heard about over the last few days and is referenced. Can you give us your views on its relevance in the determination of the application?
Yeah, the strategic landscape capacity assessment, or the capacity assessment I'll probably use just for ease, is referenced within our local development plan policy, and it will continue to be referenced within our local development plan policy. The council considers that it is still relevant because it is based upon a sensitivity study of the landscape, and although plan and policy may have evolved over the years since its publication in 2014, fundamentally the landscape sensitivity has not changed, so the council does consider it is still relevant to use as a starting point of assessment as opposed to an end point, and that starting point really allows us to understand the limitations of the landscape, the sensitivities of the landscape, and allow us to then undertake a landscape and visual impact assessment as part of the consideration of the application. Sorry, I'll apologise again.
That's great. We do have the webcast to refer back to if I don't catch everything. Can I hand over to yourself, Mr. Herriot?
Sure. I think there's probably agreement, actually, between the council and ourselves on that. And we heard Mr. Steele yesterday also, under cross-examination from Mr. Trinick, conclude that ultimately it's a sensitivity study. So as long as it's reviewed and used in that context, and any comments about capacity are dealt with cautiously, shall we say, I think there's agreement that therefore it's a starting point, but in terms of relative sensitivity only, noting that the study does actually say there's no areas of Aberdeenshire suitable for extensive wind turbines. And that's in a capacity context rather than a sensitivity context.
That's great. And would you like to add anything to that, or you okay with that? Okay, so moving on to the emerging LDP that should be adopted, as you said, in the next few months. Are there any key differences between relevant policies that we should be taking into consideration, or that you should be flagging up for us?
I think, a detailed comparison of the current local development plan policies and those within the emerging policy is covered in some detail in my hearing statement. It's section 5.2. So I won't give a full detailed run over everything, but essentially I think, there's no fundamental changes in the direction of policies. They align, although wording may have altered somewhat. But essentially the themes within the 2017 local development plan still remain within the emerging plan. I would make some points as to what could be considered some key changes. There has been clarity added in terms of the climate change policy as to what should be considered as part of, an assessment of an appropriate location. So that is essentially a replication or similar of the list of considerations within policy, paragraph 169 of SPP, and also 19K, I think it is, in draft MPF 4. There's also the removal of the orange hatched area within the spatial mapping, which I think is probably quite key. And then I think next I would just add that clarity has been added to the historic environment policy, where clarity of the current plan indicates that any impact on setting on assets, would be contrary to policy, whereas the addition of the word adverse has just been added for clarity there. And there's also some flexibility added where impacts are unavoidable, they should be mitigated and justified. But I think that's all I would draw your attention to, and just reiterate that a comparison is within the hearing statement.
Thank you very much for that. And are there any key differences that you'd like to highlight for us?
Yes, there are. I'll start with C2, policy C2, and I think largely in agreement with what Ms Tully said there about the removal of the orange hatching from the associated climate change map. And I do agree with Ms Tully that that is key in terms of the locational issue, locational acceptability, and that goes to the heart, I think, of reasons for objections 1A. Also, the commentary on the strategic landscape capacity assessment has been modified. It has been retained, I agree with that. There is reference to it being retained. But I've noticed that the initial reference to it being valid for the very large turbines now being proposed has been deleted, or is recommended to be deleted. So I take that as key, and goes back to the comments I've just made on the weight you give to that as a capacity study versus sensitivity study. And I think that that recommended change builds upon that. That deals with C2, noting also that the criteria for assessing renewable energy applications has been expanded compared to the adopted policy C2, and it now in many respects reflects paragraph 169 of SPP. The policy I think has got the biggest change to it, and will lead on to in cultural heritage no doubt as well, is policy HE1 as it relates to scheduled monuments. The original policy, the adopted policy, and the policy as proposed did not make any reference to integrity of setting of scheduled monuments. Talked about setting per se, two different things, and that's referenced in the examination report. So we've got, I'm afraid to say, but policies, in my view, they're a bit at odds with each other. So we've got policy HE1 as recommended, and policy, HE 1.1 and HE 1.5. Both in theory could apply to scheduled monuments, if you look at the title. HE 1.1 refers to impacts upon setting only. So in my view, it's not consistent with SPP 145. Policy HE 1.5, the title of which relates to scheduled monuments and archaeological sites, does refer to integrity of setting. So that part of it, at least, is now consistent with SPP 145. So we have a slight tension there, in my mind, between HE 1.1 and 1.5. And in that situation, I think when you're looking at the impact upon the scheduled monument, in this instance, it's 1.5, because that's more closely aligned with 145 of SPP.
I'm just coming to amplify there a bit. I know I'm addressing somebody who knows these policies well. That I'll be blunt, I found HE11 and HE15 rather curious in their current form. That, as recommended, HE11 says we will resist development and adverse impact on the character, integrity, or setting. So any impact, any adverse impact on the setting, not the integrity of, the setting will be resisted. In HE15, it's headed scheduled monuments, but actually doesn't say that in the text. It says development on nationally or locally important monuments. And I don't know what that means. I assume that nationally important is scheduled, but it doesn't say so. So there's a bit of doubt in that. But assuming that this policy does apply to scheduled monuments, because it's nationally important, or having an adverse effect on the integrity of the setting. So there's the inconsistency between HE11 and HE15. will be allowed if there are exceptional circumstances. Well, so far so good. That's SPP 145. But the words that trouble me have been retained, and it's not yet adopted, so I'm able to still query the position. It's including those of a social or economic nature. I don't object to that, but what I do have a problem with is the words, and there is no alternative site. And that goes way beyond anything in SPP 145. It's wording you only normally find for SPAs and SACs as part of a legal test. I don't see a justification for no alternative site. I'll say this in closing submissions. If it gets adopted in this form, well, we're under Section 36 anyway. But I want to make that point, that I find it still a, I'll be blunt, unsatisfactory policy.
Any of the points that were raised there, would you like to come back on at all?
I think it's very helpful they've been raised. I think it's probably going to be more useful for us to do our response in writing, so we've got a chance to consider that. I just pause to note that I don't think you were the reporter dealing with this chapter in the plan.
Okay, so that is all of the items we had.
Sorry. Excuse me, can I just make one other point on another policy?
Yeah, sure.
Yeah. Policy E2, which relates to landscape. There's an addition, a recommended addition there, which relates to the introduction of the word significant into the policy. So policy E2.2 now reads, in relation to development impacts, development that has a significant adverse impact on the qualifying interests of a special landscape area. So that's an addition to the draft policy, which wasn't there previously, which originally just talked about developments not affecting the not adversely affecting the qualifying interests. So that the bar has been raised, if you want to put it that way. We're now talking about the significance of the effects, whereas before it was effectively any adverse effect.
Perhaps I think the best thing for your microphone is it's a bit crackly, a bit further away from it. I think that's if you're too close, it doesn't like that.
Thank you very much. Is there anything further on E2?
Not on E2, but on E. Okay.
Would you prefer, as you said, to just hold things until afterwards, and I won't go backwards and forwards on these ones, and unless you raise your hand?
Unless there's a specific point we want to come back on, it's very helpful for Mr. Herriot to outline these now, and then we can respond to them in our closing submissions, and then the applicant will have the opportunity to respond to them.
Perfect, thanks.
Thank you. And in a similar vein, observations on policy E.16, which relates to protected species, and the addition of a word there, which now reads, development must seek to avoid any unacceptable detrimental impacts on protected species. So the inclusion of the word unacceptable there is an addition to the draft policy, which originally read, development must seek to avoid any detrimental impact. So I think the addition of the recommended wording effectively introduces what I would call a more appropriate development management test, recognising that not every impact upon a protected species, irrespective of significance, leads to policy conflict. And I think the change recommended brings that flexibility into play.
Does that conclude your comments on the policies?
It does, thank you.
Okay, thank you. So we've worked our way through the topics that were initially highlighted, but there is space then at the end for any other matters parties want to discuss. We have got indication of one additional matter from the applicant. Is there anything from the other side?
Yes, it's just to address paragraph 4.3.27. I think it's in Mr Herriot's hearing statement regarding the effects on SLAs and the reason for objection. I just want to say I think it's, I've expressed the word any in the reason for objection, and it is just, my expression. I'm not saying that there are no benefits. I'm just saying that I consider that the benefits do not outweigh the impacts. So that's probably miswording from myself.
Thank you. Do you want to comment on that at all, or do you want to just take your additional item?
No further comments on that. That's fine.
So if you give us your additional item, we'll...
The additional item relates to something in Mr Kelly's hearing statement, where he refers to the constraint payments made to Windfarm owners, operators. And we just wanted to address this so the facts are clear. Of course, he is correct that the operation of turbines does at times have to be constrained, and constraint payments are made, so you're being paid not to operate, to put it bluntly. And that is due to the capacity of the existing transmission system to transport electricity south to England. But I think what's not recognised is why this happens and what the true financial consequences are. What happens is that there are a number of circuits which enable transmission of electricity from north to south. During the summer months especially, some of those circuits are taken out of commission for repair or replacement or whatever. That doesn't mean there's no demand south of the border for electricity, or there's no provision of wind relative to demand. It certainly doesn't mean that. The demand simply has to be met elsewhere, south of the bottleneck, if you like to call it, created by the circuits going out of commission. What National Grid then has to do is to secure electricity from another source to meet demand further south. And typically, because they're quick response items, that will be gas-fired power stations. So obviously National Grid has to provide available wind farms for compensation for producing electricity they can't sell. And the rough cost of that is it's probably more now, but was between about £25 and £35 a megawatt hour. Let's call it 40. It may have gone up further. I don't exactly know. It doesn't matter because the cost to National Grid of supplying electricity from gas instead was in 2021 £187 per megawatt hour. And we rather suspect that with things that have been happening further east, the prices will go up again to over £200. So that's the balance that perhaps Mr Kelly doesn't acknowledge. So yes, we are paid, the wind farms are paid a constraint payment to curtail generation. It's not to do with supply and demand, it's to do with the bottleneck. And the consequences to the system are an extreme expense to do with the cost of the replacement generation. So I would join with Mr Kelly in approaching National Grid and asking them to sort out the problem. Thank you.
Would you like to add anything there, Mr Kelly?
Nothing in particular to what I've already said, except to, in many ways, agree with Mr Trinick that we do have a dysfunctional system. Maybe that was a constraints payment setting it off. So again, just to confirm, yes, there are many systematic issues facing grid electricity generation and transmission, and to that extent I agree with what Mr Trinick has said.
And there's nothing from that side of the room on this matter.
Could I just make one final factual observation? And this relates to the Council's policy hearing statement, paragraph 5.2.4, which reads, for the purpose of this inquiry, policies C2, E1, E2, HE1 and R3 remain the most significant. Just an observation that there's no objection on policy R3. It does not feature in any of the reasons for objection. Just a factual point.
I think R3 deals with hill tracks, and it's a relevant policy for you to have regard to, whether or not, I mean, I'm sure Mr. Herriot's entirely correct, but it's a relevant policy for you to have regard to, and you've heard lots of evidence on the impact of hill tracks. It just provides you a framework, and probably only a partial framework in which to consider that evidence. That evidence will be considered under other headings in any event.
Okay, if there are no additional points to be made on any of the matters, are you?
I'm just reminded that we did actually accept that in our paragraph 5.2.41, but I don't think that adds to what I've just said.
Okay, well, thank you very much for your time this afternoon. We have no additional questions ourselves. We've covered all of the matters from the statements that we felt that we would benefit from additional discussion on. So what we'd aim to do now is to break for lunch for an hour, following which time, when we come back, we would move initially into the cultural heritage and historic environment session as scheduled, and then, should time allow, we'll thereafter cover the draft conditions session. Thank you. So that will be 1:30 for reconvening. My name's Stuart West, and I'm joined this week by Ms Haywood. We've been appointed to consider the application and submit our representations in a report to Scottish ministers following the inquiry process. As this is the first session with an unrepresented third party, and because there are a couple of different folk present, I'll maybe talk a little more about the process and the context for folk. So the formal inquiry sessions have now concluded, and these hearings have a slightly different format than those that were involved in the morning session will have realised. Primarily, there's no cross-examination of witnesses. Rather, sessions take the form of a structured discussion, following the agendas that have already been circulated. Again, you'll no doubt hear people saying things that you might not agree with or you don't agree with, but it's important to remain polite and respectful, giving other parties time and courtesy they need to express their views, give their evidence and answer questions in the same way that you'd expect this to be done for you. The purpose of the hearing session isn't to persuade us of your point of view, but to help make sure that we understand the respective position of parties, and where there are differences, the reasons for those differences, so that we can clearly set them out for ministers in our report. In addition to the evidence that we're here today, as I mentioned on Monday, we are going to take all representations that have already been submitted into consideration in the assessment of the proposal. Before we begin again, it's the member of public in the gallery as well, we just need to make sure that people remember to adhere to the COVID guidelines that are currently in place. For this venue, we've arranged for people to sit a metre apart, and when you're moving around, unless you're exempt, try to remember to put your masks on. Before we start properly, I'd like to take a note of the parties that will be participating for the relevant sides of the room. And we'll start with the applicant, Glendye Windfarm Limited.
Thanks, Marcus Trinick, but I doubt that I'll do much talking in this session. Most of it will be done by Mr. Moody to my left.
Good morning. Good afternoon, sorry. My name's George Moody. I'm from CFA Archaeology.
No, you can't be closer because the microphone doesn't like that, and there's an interference.
As close as I dare get. As close as I dare get. If I speak up, will that help?
Thank you. You're coming through clear on the. He's coming through clear on this one. Is there a problem with the speaker on the microphone in front of you?
Okay, can I try that again? Is that any better?
Maybe try and speak up, as if you didn't have a microphone.
Okay, thank you. And then when we are using the microphones, if you remember to press the button so the red lights come on when you're speaking, and then when you're done speaking, to turn them off.
So my name is James Finley, Queen's Counsel. To my right sits Elizabeth Tully, who's a senior planner in the Strategic Development Delivery team, and to her right, Ewan Brown, advocate. Ms Tully is likely to do most of the talking.
And for Clan Strachan?
Hello, my name's Rob Strawn or Strachan. I will answer to either, and my official title is Commander. And I'm representing Clan Strawn and Strachan's and Strawn of both pronunciations.
Thank you very much. I'll stick with the Strawn then for both yourself and the clan. So everybody should have received a copy of the agenda. Has everybody got a copy before them, electronic or hard copy? Yeah. As I've said, the procedure at hearing process is quite informal, so we'll lead the discussion, primarily myself, based on the points listed in the agenda that's been circulated. There's no need to read out your statements, but as we go through the points on the agenda, it should enable you to put across your point of view from your statement to give us the information that we need. There won't be any cross-examination, but you can ask questions of each other if you don't understand something. Just put your hand up and I'll allow you to speak when the other person's finished talking. We'll decide who to ask about a particular item on the agenda first, but everyone will have a chance to say something. So we may ask you to comment on what others have said too. When we've decided we've got enough information about a particular item, we'll move on to the next one. And again, please remember, we do have to take some notes, and we're not, we're not machinated, so we may ask you to pause once or twice just so that we can take reference points and make sure that our notes are effective. We've been to most of the viewpoints. We've seen around the general area. At the end of the inquiry, we'll decide to whether or not we need to make any additional ones above and beyond the one that we're going to take tomorrow, after hearing the evidence from all parties. Do parties have any questions about the procedure before we continue? No. Okay. So it's also important to note that we have already had a dedicated inquiry session on landscape and visual impacts, and it's not our intention to revisit that, the things that we've already covered during that session. The focus of this session is the special character, cultural significance of a scheduled monument and how the proposal will impact the monument and its setting. We'll be considering what elements of the setting are integral to its special character or the understanding of the monument, and whether or not the proposed development will affect this. Thereafter, we'll consider Clackenben and the wider historic landscape. We'll seek to understand the nature of the landscape, its relevance, and whether it's susceptible to change. Could I first invite the applicant to describe Cairn Mount Monument and its setting?
Sorry, thank you. Well, Cairn Mount Scheduled Monument is a large Bronze Age burial cairn constructed largely of stone. It's about 15 metres in diameter and survives up to about 3 metres in height. It sits on the watershed of the two watercourses that run respectively to the north and to the south, and it's positioned on the south-facing slope, slightly to the southeast of the highest point of the Cairn Mount Ridge. In terms of its cultural significance, it has scientific value as an archaeological monument that contains evidence of burial practices in the period to which it pertains. And there's an adjacent, smaller cairn that's much more degraded that lies immediately to the southeast of the larger cairn, buried in the heather at the roadside. You need to sort of look to find it, but it is there just at the side of the road. And you can see that as a heap of stones or a spread of stones in the heather on the roadside of the fence line. In terms of its setting, as I've described already, the key points are where it is located and its prominence in the landscape there, and its relationship to the landscape around it. In common with a lot of Bronze Age burial cairns, these are generally sited in specific places that had meaning to the builders of the monuments. So in order to understand its monument, you have to understand its relationship to these other features in its vicinity. And when you're at Cairn of Mount, the key thing that strikes you is the open aspect view to the south and to the southeast in part. And when you stand at the monument, you can see, when you're looking towards the south, you can see the burn that runs off the hill that leads in directly into the Devilly burn, I believe it's called, that then leads you down to the Luther Water in the lowlands on the Howe of Mearns. And I believe that relationship is important because Bronze Age burial cairns were often sited close to watercourses. Now, whether that was specifically in relation to the water connection or whether it's because watercourses were at that time in prehistory the most convenient way of moving from one place to the next. Very much as we do today, you'll find that most communication corridors relate to sort of river valleys. Yeah, so that's, to me, that's a key aspect of the setting. Another aspect of its setting is the view to the north, following the valley of the Glendye, the Dye River, down towards Strawn and then on to Banchory and ultimately Deeside. So it's that connection between those two places in the landscape that's important to understanding the site of the monument. You can see the monument when you're down in the Howe of Mearns. That is also a key aspect of its setting, I would say. When you're travelling north along the B966, I think it is, just east of Better Cairn, you can see the cairn actually on the skyline. So it's kind of, if you like, it's marking that route through the hills, and you can then follow the river up to the cairn, and then you're over the top. The positioning of the cairn is critical in that respect because it's skylined in that view. If it was set any further north, then you wouldn't be able to see it from that southerly aspect, I suggest.
That's excellent. Thank you very much. Do any other parties, starting with the council, have anything to add to that description of the setting?
No, thank you.
Commander Strawn.
I don't have anything to add to how he's described the setting, other than he's saying that you look north. I mean, yes, you look north, you look south, you look east, you look west. I mean, you look from every point of view. In terms of strategically, from the Clan, Strachan and Strawn point of view, it was a watch place where they could watch over the Mearns. They could look towards the sea. They could look towards Dundee and Perth, and they could see any approaching foes. And it meant that the enclave of which it's likely that we've defended in Strawn was able to be viewed from that Cairnmount position. So that's all I have to add on that.
Thank you. I think we'll come on to that in part 2, where we're looking at the significance, the later significance. I suppose at this point we're trying to understand the special significance as the scheduled ancient monument, and so what its special characteristics are and how they're going to be affected. And then we'll look at the wider historic landscape and the relationships with the clan afterwards. Thanks. And again, starting with the applicant, taking the HES designation description and your own professional opinion. So what contribution does the setting make to the special character or significance? You've touched on that already, but is there anything specifically in the designation as well that you'd like to point out?
Sorry, in terms of its setting, the only thing that's really relevant in the designation is the statement that its spectacular sighting gives it particular significance. And I know in the document that sighting is actually spelt incorrectly, but I think we can forgive them the odd typo, as I'm sure we've all made those in our time. I certainly have. And so I take that to mean the description that I've just sort of given to you in that relationship. How prominent it is in particular, and again what I would call spectacular views.
Okay, thank you. Is there anything on the designation from this side?
No, just the spectacular sighting.
So it's clear, I think, that, it's clear that the monument's not going to be impacted directly physically. This isn't in dispute at all by any parties. What's disputed is the impact of the proposed development on its setting, or maybe more significantly on the integrity of its setting. So could the applicant please explain the conclusion within the statement that the integrity of the setting and its cultural significance will be preserved? I'd appreciate if you cover the bullet points that are in the agenda when you give your answer. And given the potentially lengthy description that might follow, if parties could just make a note of any questions, we'll come to those at the end and try not to interrupt you at all. I mean, you may have already covered a lot of this in what you've just said, but it's just to work through those points specifically.
Or are you asking about its cultural significance?
Well, I mean, the integrity in terms of, the integrity of its cultural significance, I suppose, in terms of, insofar as the setting is significant, how is the development going to impact on that, or otherwise?
I think the reason we're asking the question does relate to the wording of SPP 145, that, as Mr. Moody has explained, setting is one contributor to cultural significance. So you can look at it that way, but SPP 145 only deals with setting. So do you want us to just address the setting aspect as opposed to the wider cultural significance?
Yeah, I mean, I think as we've said that nobody's implying that there's going to be any direct impact on the monument. So the only impact, not physically, to the scheduled area. So the only impact is on the setting.
Okay,
so
that's
yeah,
fine. We're clear.
The first thing to say is that SPP requires us to preserve the integrity of the setting. It doesn't just say protect its setting. There's that specific word, integrity. But this is a word that's sort of not defined anywhere in any of the guidance. It's not clear what is entirely meant. But what I and most of my professional colleagues would understand is that the integrity of a setting is maintained if the principal characteristics of the setting that contribute to the cultural significance of the monument are retained, and it would continue to be possible to appreciate and understand the scheduled monument in its setting. So when we're talking about the preserving the integrity of the setting, what we're saying is, can you still understand that monument and its relationship to its surroundings in the presence of whatever the development might be, whether that might be a wind farm, a factory, a new roads project, or anything, basically that requires consideration of how that might impact on our ability to understand that monument and to appreciate it and to experience it. Its significance. And it's about experiencing it and appreciating its significance that is important, and that goes back to the various characteristics that contribute to its cultural significance, of which setting is only one aspect. Yeah. So there are other, as I said before, there are kind of other aspects of cultural significance that would not be at all affected by this proposed development. As you've rightly pointed out, it won't be directly affected, so there'll be no physical impact. Its scientific values, its archaeological interest will not be affected in any way. Its aesthetic qualities will not be affected in any way. The monument will still be a pile of stones. And its various associations will not be affected adversely either. So it really comes down to this. Can we still understand the monument and its setting? And are any of the key characteristics that contribute to that cultural significance adversely affected? And as I said earlier, the key characteristics are its prominence and this open aspect to the south, which I think is alluded to in the HES scheduling document.
So in terms of the bullet points that we've got there, is there anything you'd like to say about the difference between the LDP supplementary guidance of the Cairn and Mount's consideration as a scenic viewpoint as opposed to a heritage asset that you touched upon in your...
Yeah, absolutely. The purpose, as I see it, of a scenic viewpoint is a place to go to look at the scenery. Yeah, it's a place you can stop on your travels. It offers you a scenic view of a landscape. The scenic viewpoint that's referred to in the SLA supplementary guidance is not the same location as the scheduled monument. The scenic viewpoint is 200 metres further downhill, where there's a parking embayment on the old military road. And there's an information board at that point that points out various points of interest in the surrounding landscape of the view to the south. And it's clear that that scenic viewpoint is oriented towards the south, because spectacular views of the Howe of Mearns and the coastline and the various features amongst it. The heritage asset is a completely different place. It's on the summit of the hill, and it's within a different setting. So they're functionally different things.
Yeah, understood. Thank you.
Yeah, in terms of the test, the policy test in 145, again we come back to this notion of, is the integrity of the setting preserved, or is it adversely affected? And I don't believe, for the reasons I've explained earlier, that the integrity of the setting would be adversely affected by this proposed development, because the key characteristics that contribute to its cultural significance are the factors that I've already described.
That's great, thanks. I'm gonna move over to the council now for you to explain your understanding of the monument and its setting, insofar as it relates to the objection, and so that we can just sort of better understand the position there.
Yeah, thank you, sir. I think, as a general point, I would not disagree with Mr. Moody's understanding of the setting. I think there's a broad agreement there. I agree that the location of the monument is not accidental. I think the builders of the cairn would have, absolutely taken into account the water courses that Mr Moody talks about. And through discussions with the Council's archaeological colleagues, we would consider that the cairn was built high up on a prominent and dominant landscape, so that it can be seen and see from all vantage points, so we can remember the people or the persons to which it's dedicated. And I think Mr Moody would also maybe agree with that in his hearing statement. I would take the intervisibility with Clachnabin as also being a key point to the setting, and the natural rock outcrop on there being visible from the cairn, and that is perhaps deliberate. I think in regards to setting, my concern is that the Windfarm would introduce a human influence into the setting, and really as a consequence of that, the influence would obscure the features as to why the cairn was located where it was, obscuring or masking the water courses, and just bring in a level of misunderstanding as to why the cairns were located there. I think, as well as if a wind farm, when I speak about the Clachnabin intervisibility, I think if a wind farm was introduced into this landscape as you were standing at the cairn looking towards Clachnabin, I think it could be, there may be a struggle of appreciation as to the relationship that the cairn has with the Clachnabin and the tor on the top of the hill, because the wind farm would introduce a new feature in the setting, and also with it bring moving elements that would work to distract views towards Clachnabin. Sorry, sir, can I just come back in? In response to the SLA and the reference within it, I think, the supplementary guidance is for special landscape areas, and I think it's obvious that that document would use the term viewpoint, as opposed to heritage asset, because that is the focus of the document. It is to do with landscape, not cultural heritage.
So just going back to yourself briefly there, you didn't mention the intervisibility between the monument and Clachnabin. Would you accept that that is another key part of its setting?
It is the first time we've heard that from the Council's position. They've never mentioned it before in their reasons for objection or in their hearing statement. I do acknowledge it in my hearing statement, because natural features can sometimes be important in relationships with ancient monuments. Whether or not that is the case here, I mentioned it in my hearing statement because of it is a prominent feature in the landscape, and it does, in some respects, resemble a cairn when you see it from a distance. It stands out on the hill in the same way that a burial cairn would. Whether or not it's an intention on the part of the builders of the cairn that is an important relationship is a consideration that we will never know. We can never know whether that was important to the builders of the cairn. What may have been important to the builders of the cairn will be its relationship with other monuments of similar type in the wider landscape. And I picked out in my hearing statement that there's a similar burial cairn on the top of Curlock Hill, which is at the very north end of the Mid-Hill wind farm, much closer to the wind farm than this particular instance is to Glendye, for example. Which of those two monuments was the first to be built and which references the other is a moot point. They are broadly contemporary monuments and they are intervisible, so I consider that to be a key aspect of its setting as well. Yeah, but the key, as my colleague has pointed out, the key views that I have already identified are those that to the north and to the south that follow the river valley system.
And will the, as the council mentioned there, the development, the proposed development would interfere with those views or obscure them? Would you agree with that?
No, I wouldn't agree with that at all. The proposed development is in a different direction. I don't see the views to the west as being particularly important to in relation to understanding the cultural significance of this monument and its setting. And I also take issue with the fact that what the council was saying there, that this introduces a modern man-made facility into the landscape. We already have Mid-Hill Windfarm, which lies to the east of the proposed development, so this is not a new element, shall we say, as such. And I would go on to say that even in that case, that will not affect the integrity of the setting the way we understand that monument and its landscape.
Thank you very much. I'm just finishing my notes. Would the council have anything further to add on the matter of the setting, the integrity of the setting, or the understanding of Cairn Mount?
Sorry, sir. Thank you for that break. I have prepared some responses to the points that you've made in the agenda. So, would you? I feel like I've covered point 1 and point 3. Would you like me to talk about point 4 or point 4 in particular?
Points 2 and 4, we were going to. It might be worth coming on to 2 first of all, because it's just been pointed out that Mid-Hill's visible from the monument. So when we start looking at the focus of views, which it's been contended north and south along the watercourses, and the intervisibility between Clachneben potentially and the monument and the contemporary monument, the contemporary similar monument on Cairloch Hill. Could we just maybe talk about the cumulative effects? And I recall the discussions within the statements of the potential, the vista, the encroachment in that panoramic.
Yes, thank you, sir. I accept the point that there are views to the south and southeast, and they are lovely views. They're important to the monument, but I don't think there's any reason that should be singled out as a main focus of the view. We've been through, earlier in the session that the HES schedule and document doesn't particularly pick out one view. It just references the spectacular sighting as a whole. So I don't, on that point, don't think that the south and southeast views should be referenced separately. And I think it's also arguable from discussions with our archaeology service that, if there was a main view intended by the builders of the cairn to be towards the south, then I think the cairns could probably have been located further down on the southern slope of the hill to kind of command that view towards the south or the aspect towards the south, and really kind of block off any other views from it. As we've heard, it's a high point, so there are views 360 degrees around it. So yeah, sighting further down a southern slope would kind of restrict views elsewhere. And I think, the introduction of the development would kind of have 2 effects in terms of cumulative effect. The first point I would make would be to bring a sense of human intervention into the scape. And closer than other man-made are already featured. So the point was made that development was already in the landscape, and I accept that. I think it's around 6.5 kilometres from the Cairn Mount, whereas the proposed development would be around 3.6 kilometres to the nearest turbine. So it's really bringing that sense of encroachment of influence, man's influence, to be closer to the monument. And I think, you know, the lack of man-made influence is a key feature of the setting of the monument. The second point that I would make would be with regards to the encirclement of wind development around the monument. And when I talk about encirclement or, you know, closing the ring of development, I'm not talking about there are wind developments within a mile of the development all around it. I'm saying, you know, when you look at viewpoint 3 from the EIAR, which is from Cairn Mount, there are 4 photo montages, and in 3 of those there are already wind energy developments constructed, operational. Those identified, some of those identified as at scoping or pre-planning, are now approved and under operation, under construction. So that's what I mean when I talk about the encirclement. But, you know, bringing that human influence closer to the monument is what the point I'm trying to make.
Okay, thank you very much. So before we go on to the other bullet, we'll move back to yourself to respond to that point. I mean, you mentioned earlier that, I suppose just before you do that, the prominence, I suppose with a burial mound, its views towards it as opposed to views out from it are normally of significance, because I suppose dead people are interred in there that don't enjoy the view. So I think what you were saying earlier about its prominence and its spectacular sighting is based upon observations of it rather than observations from it. But I was wondering if you'd like to respond to the points raised.
Certainly, yeah, I certainly would. Firstly, in relation to the locational point that was raised by Ms. Tolley there, if the monument had been sited further downslope, then it wouldn't have been such a prominent feature in views from the south. It would have been backclothed by the hill. So its prominence in its spectacular sighting would be lost entirely, and it wouldn't stand out as a landmark, which I believe is intended to do. If you go to the view locations that I suggested to you along the B966, for example, you can see the cairn is quite clearly on the skyline. It's not beyond the skyline, it's not in front of the skyline, it's on the skyline in that view. And that's a deliberate action on the part of the builders. So I don't believe that they would have moved it downslope simply because they couldn't then see views to the north. I believe that the position in relation to the watercourses is key to understanding its setting in that regard. It's also sited directly adjacent to the old military road, which, again, we as archaeologists believe probably has a much earlier origin as a routeway through the hills than the mid-18th century. It's been a droving route for many years before that, and it was probably has even more ancient origins, as I explained earlier on in my statements there, because it effectively connects 2 river systems that connect 2 geographically different locations. The Howe of the Mearns is the lowlands, and the River Dee to the north is another valley system. So it's a connection route between those 2 places through the mount, of which there are several, or in other locations.
And it's intentionally sited at that location on the hill to be viewed from both locations?
Correct, yes, that's my interpretation.
And in terms, in terms of encirclement and encroachment, do you have anything to say?
Could I just ask the Council, when they say 3 wind farms, which of the 3 wind farms they have in mind?
I think you said 3 of the montages contain wind farms, 3 of the 4. Is that?
Yes.
It was from viewpoint 3. There are 3 wind farms. Can you just remind us which ones they are?
No, I think you misheard Mr. Tunick and the reporter heard correctly, Tullow was saying that if you look at viewpoint 3, the wirelines or photomontages give are split into 4 sectors. In 3 of those at the moment, there are wind farms either in existence or under construction. This will be in the 4th where there isn't one. So it's the 3 sectors rather than 3 wind farms that she was referring to.
Nevertheless, I just want to confirm that we're talking about Midhill, we're talking about Tullow. No, we're not talking about Tullow.
Well, it's whichever ones that are in the 3 visualisations that you have provided. Those are the ones you're referring to, isn't it?
All right, I'm just trying to establish which ones they are.
There may be a list of them, and we can provide that in our closing submission. But
I'm being persistent on this, is that I think it is important to identify which ones we are talking about. If you look at 613A, there is Glendye. If we're looking at 613B, there's a European offshore wind farm, and I wonder if that's one of the ones that people have in mind. And then if we look at 613C, there's a variety of potential there. You've got Craig Neal, you've got Fetteresso, you've got Midhill, but then there are other wind farms, offshore and onshore, which are noted in that 613C. If you look at 613D, we've got a variety of offshore. So I think we need some clarity on which are the wind farms that Ms Tully has in mind when making the encircling argument. I think it's a fair question.
No, I'll accept that. So are there any in particular that you'd like to mention now?
I mean, nothing in particular. It is just a case of going through each of the montages and seeing where there are influence. So you're correct. There is the European offshore. Sorry. Figure numbers, we're looking at figure numbers 613A, 613B, 613C, and 613D. And, sorry, sir, the figure 613C, 613B, 613C, and 613D have wind energy developments included within the photomontages and wire lines.
And do you believe that all of those contribute to the feeling of encirclement?
Yes. Yes, I mean, there is an influence of energy development around, and they all do contribute to the encirclement, but there is definitely some more than others. And, I think Midhill 1 and 2 are definitely the main ones because they're the closest. But I would say all of them have an impact, all of them are visible and are sensed from Cairn Mount.
Yeah, I take the point made by Ms Tully, and I don't dispute that there are wind farms in the wider landscape in 3 of those photo montages. What I do take issue with is the argument that amounts to encirclement of the monument when we talk about its setting. Encirclement, to me, and I'll take this from a dictionary definition, means to form a circle around, to surround, enclose, or cut off. And that is not my perception of what would occur if Glendye were consented. I've looked at these photo montages, and most of the developments that you see in any of those photo montages are at considerable distance from the Cairn and Mount Cairn, and they do not amount to what I would call large-scale, a proliferation of large-scale developments. They are what I would describe as, if you like, I would see those as as being structures in the landscape. I do not equate that with a large-scale development or large-scale developments encircling the monument.
Thank you.
Add to that, if you look at figure 613 and the AI, that tells you the distance. That European offshore is 45 kilometres away. 29 is sea green, nearly 50. 35, 36, Inchcape and sea green. These are a long way away. And so if Ms Tully is saying this contributes to the feeling of encirclement, we have got a very fundamental disagreement.
Yeah, well, we've taken both sides, and we've made a site visit to the site. We've had a look at it ourselves, and we've noted both positions, and we'll take that into consideration in our assessment. In terms of the encroachment and the feeling of encroachment, is there any specific comments you'd like to make with that regard?
Not particularly. I would only point out that, again, it's not the shall we say, the visibility of these developments that's the issue here. Because I think, if I can just go to my notes here, Historic Environment Scotland are quite clear on this in their guidance in the EIA guidelines, and that's CD 1108, paragraph 43, where they say quite clearly that visual change should not be equated directly with adverse impact. Rather, the impact should be assessed with reference to the degree that the proposal affects those aspects of setting that contribute to the asset's significance. So we're coming back again to this integrity issue. Can we still understand and appreciate that monument and those aspects of its cultural significance in the presence of the proposed development? And it's been accepted that Midhill has no adverse impact on the integrity of the setting of this monument, and I don't believe that Glendye does either.
Just for my own clarity on my note there, so that was paragraph 43. Can you just give me the reference again just for the document?
CD 1108.
Okay, thanks. Unless there's anything further to add on that, I'm happy that we've got both sides on that one. And I'm happy to go on to the fourth bullet there. Before we go to the council, I'll maybe just check with the applicant. So, again, just for clarity, the fourth bullet point just says the impact of the proposed development on the integrity of the setting and the significance of the monument, in particular in regard to the policy test at SPP paragraph 145. So have you got any specific comments on that before I hand over to the council?
Not really. I would only point out that the council have not really addressed the integrity issue.
Okay, so we'll go over to the notes you've made on that one, Ms. Tully.
Thank you, sir. So paragraph 45 of Mr Moody's statement says that the impact is assessed as being of medium magnitude, resulting in an effect of moderate significance. He goes on to say that it doesn't mean that there would be an adverse impact on the integrity of the setting. Now, I don't quite understand this because the Cairn Mount is a single point setting. You talk about the location on the watershed and the intervisibility with Clacknaburn and intervisibility with other monuments. From this point, and the introduction of the development therefore must have an impact on the setting and an impact on its integrity, because it is that single point. So if we talk about Hadrian's Wall as a comparable, Hadrian's Wall is a long linear feature where you may have a development that has an impact on part of Hadrian's Wall, but you can move somewhere else and have a completely different perspective, and no integrity has been lost of Hadrian's Wall. But here we're dealing with a single point, so I think an impact on the setting therefore has an impact on the integrity of the setting here. I think one final point that I would make is, the cultural appreciation of the modern visitor would, not be the same should the development go ahead. It wouldn't be the same as the predecessors that they would have felt. So I think, again, the integrity of the setting is being compromised because that feeling, the appreciation would be different. And I'd just like to end on a final point. When you're travelling, when you're visiting the Cairn Mount, you would generally park up in the lay-by between the Cairn Mount and the road, and you would travel to the Cairn Mount via an access footpath which runs from the east, the car park, and to the west. So when you walk through that footpath towards the Cairn, I would say one of your first views is of the development to the west, and then you'd kind of turn your back on the development and experience the Cairn. And then as you were leaving the Cairn, you would again face back towards the north with an aspect of the proposed development, and then you would turn your back on it again and leave via that same access point. So I think, your first experience of the monument would be of a wind farm development, and your last experience of the monument would be the wind farm development, and it's essentially bookending that visitor's experience. So again, I think the integrity of the setting would be compromised.
So can I just add to that as Mr. Tullow has explained, Council accepts that there can be an effect on the setting of a heritage asset may be capable of being distinct from an effect on the integrity of that same asset in some circumstances. And earlier this morning we were looking at, because Mr. Trinick, I think, drew our attention to the report on the proposed LDP, in paragraph 4 of that, I think it's CD, I can't remember what the CD is of it, but it's electronic page 319 of 1681. The reporter makes just that point. But as Ms. Tullow has explained, in this instance, what Mr. Moody is seeking to do is distinguish between the two, where you have, with the particular asset that you're seeking to protect is effectively a point. It's it's two cairns, but they're in the same location. And the distinction he now seeks to draw is not one that's drawn in the EIAR report at all. You might wish to, when you're reviewing this, compare what's the assessment in that chapter, which I think was also done by Mr. Moody, and his report.
Thank you. Have you anything to come back on that?
I think I do address that point in my EIA report, actually. I do say that, although there be an impact of moderate significance on the setting of the monument, that does not mean that those aspects of its cultural significance that are important or the integrity of the monument is not adversely affected, I think. And just find a reference for you. In paragraph 1065, I said Cairn will remain as a prominent visual landmark, and the introduction of the proposed development will not hinder the ability of any visitor to appreciate the character of the monument or to appreciate and understand its relationship with its wider landscape. Certainly. The proximity of the proposed development, 3.6 kilometres to the west, will result in a partial change to the character of its setting, and the effect is accordingly assessed as being of medium magnitude, resulting in an effect of moderate significance. An assessment that I note that Historic Environment Scotland agreed with in their response to the EIA.
Just add to that I don't think the Hadrian's Wall comparison is terribly helpful. Let's just look at Cairn Mount. There are cases, as here, where HES will find a significant effect in EIA terms on the setting of a monument, and yet does not object because that amounts to if you like, a matter of national interest in terms of SPP 145. And that is exactly what both HES and Mr. Moody have found here. And I note that this is the first time today that we've heard any view from the Council on SPP 145. Up till now, its evidence has been expressed in terms of its own LDP policies only. And when we got the hearing statement, we were expecting to see something about integrity, but we didn't. We've heard it for the first time now.
I think, unless you'd like to
I think we can deal with those, respond to those remarks in closing submissions, and that may be the best place to do it.
I think, unless you have any questions. I have no further questions on this. I understand the positions from the statements and from the information you've submitted today. So thank you very much for that. So moving on to item 2. We have fully considered the evidence provided to date, and we believe we are got a good understanding of the position of Clan Strong with relevance to the significance of the landscape to the clan's heritage. However, there will be some opportunity for Mr. Strong to, well, Commander Strong, sorry, to add details and to describe this further shortly. Before we consider the proposal and its specific context, in the first instance, I thought it'd be valuable, given the hearing statement that came through from the applicant, just first of all to describe the differences between tangible and intangible cultural heritage, just to set the. It doesn't have to be an in-depth one, not specifically to this case, but just the general principles so that people in the room understand what those differences are.
I'll have to dig out. I'll have to dig out a document if you like, if you'll just permit me for a moment.
I'm more than happy to take a moment.
Yeah, this matter is addressed in. Just bear with me a second. I'll give you the reference. It's in historic environments. In historic environment policy for Scotland, the reference for which is CD 1103 on page electronic page 11 of that document. Intangible cultural heritage is described in there as, well, it's not described as such, but it says there, established ways of managing the historic environment are often based around physical structures such as buildings and monuments. That is the tangible cultural heritage. It says, but the historic environment is made up of both intangible and tangible cultural elements, and the intangible cultural elements are more what is described in, again, just go to another document. Just bear with me. Because I can't quite find that. I can't lay my hand on that reference at the moment. No, I don't think so. Intangible cultural heritage is something that has been established as being those aspects that you can't, that are not physical aspects of cultural heritage. So it's associative elements, if you like. It's what things mean to people. And in its simplest terms.
Yeah. So it's. I understand what you're saying, and it's looking more at passed down stories, folklore, things like that.
Exactly that sort of thing. Yes, I mean we see them all the time. It's sort of rituals and festivals, that sort of thing, associations, feelings that people have for particular places. So it's much more intangible is literally the word. There is a document that Historic Environment Scotland have produced in relation to intangible cultural heritage, but that's not a document that's before the inquiry. I can give you a copy of that if you require it.
It's more just for setting the scene for the way this discussion's likely to go. So, is there anybody from the other parties that has any other understanding of intangible cultural heritage you'd like to add to the description in any way?
Yes, I mean, Strauns and Strachans, through many ages, we've got, for instance, Castle Hill in Strawn. It was a wooden fort which was burned down because by Robert the Bruce, because we were allied to the Cummins, and Cummins was the other heir to the throne, who was killed by Robert the Bruce in a church. And just because we were on the wrong side of that, Castle Hill was burned down. Now that is a topographical feature. It's a mound of earth with a tree on it, and with whin growing all over it. Well, I mean, that's something that a whole clan of people look to provide them with their heritage. So that's a topographical feature that we're looking at. And so and that extends to quite a number of other features in this landscape. And I know that, to come back to stone circles, Aberdeenshire has over 200 stone circles with the recumbent stone. Why this is important is because it shows they're thought to be 3.5 up to 3,500 years old. This predates the Egyptian pyramids and shows us that there was habitation in these lands all those years ago. That's important to us as a clan, because people who come here are looking for that genealogical evidence, an evidence they find in the landscape itself. And part of that is, I mean, people have to get to where we are, which means they have to drive, which means they go up and down landscapes, seeing what they see as they do. And it's all part of the experience. So that's the point I'd like to make on that.
Thank you very much. We'll look specifically at the landscape here in a moment, but before we look at it specifically, in terms of intangible cultural heritage, and just popping back to SPP there, so paragraph 151 that I'd referenced in the agenda there, could you just explain your understanding of how that concept of intangible cultural heritage would align or not align with paragraph 151?
Before I go there, I've actually found a relevant reference in Historic Environment Policy Scotland on electronic page 5. It differentiates between, there's a description of cultural heritage, and there's a description of historic environment. The tangible elements of cultural heritage are the historic environment. The intangible qualities are what is described, some of what are described there under cultural heritage, which gives you reference to the ICOMOS document. So you can see that in there. In terms of the question that you've just asked in relation to historic landscapes, I would say first of all that all landscapes are historic landscapes. They're all modified to some degree or other by human influence, no matter how natural they may seem. And that human influence extends back into time for thousands of years, at least 10,000 years in the case of Scotland, or more so perhaps in other parts of the world. That does not mean that all landscapes are historic landscapes as intended by SPP 151. If I can just go to SPP 151. is it 8.1? Sorry, yeah, here we go. I've got it now. 151 says that there are a range of non-designated historic assets and areas of historic interest, including historic landscapes. Now, it's not clear what that means, but it says in the following phrase, it refers to other gardens and designed landscapes, woodlands, and routes such as drove roads that do not have statutory protection. But this Historic Environment Scotland maintain what they call the Historic Land Use Assessment Map, which is a national breakdown of landscape characters in terms of their historic land use. Includes modern day land usage, but also includes within it past land use. And it's those past land uses that lead us to understand the historic landscape, and that's what I would describe as areas that bear the imprint of human activity. An example in my hearing statement is that small post-medieval farming landscape that I referenced that occupies Glendye, where there are the remains of former farmsteads, townships, and field systems that Commander Strawn may well be familiar with. That is what I would describe as a historic landscape. It's a discrete unit of land that bears an imprint of past human activity, settlement. We find them, for example, in places like Skye, for example, on the Waternish Peninsula in Skye. There's a very good example of a clearance landscape where there are a number of historic townships, sort of 17th, 18th century townships that were cleared following the Jacobite rebellions and then the replacement of people with sheep in the past. You also find them, for example, Stonehenge is a historic landscape, it's a prehistoric landscape, it's a ritual landscape that covers a wide area that has a lot of monuments, all related to ritual activities. Similarly, in Orkney, the World Heritage Site there is a historic landscape. Some of these bear designations, but some of them don't. The Waternish Peninsula, for example, does not bear a designation, so that would bring it under paragraph 151. So we talk, in terms of cultural heritage and planning terms, the historic environment, we talk about features, buildings or places that provide physical evidence of past human activity, identified as being of sufficient value to this and future generations to merit consideration in the planning system. In the HES EIA guidelines again, and that's CD 1108 on page 175, they note that heritage assets may form historic landscapes in combination with other heritage assets, which may in themselves be considered to form heritage assets in their own right. So that's what we understand as historic landscapes. So we can go to these places and we can study them and research them as bearing the imprint of, it tells us something about people in the past, how we lived in the past, etc. So then, the question becomes, is the Glendye Windfarm occupy a historic landscape? In my view, it doesn't. There are pockets of historic landscape within the Clachneben and Forest of Burse SLA, but neither in the previous SG or in the forthcoming SG are these characteristics recognised as being part of that landscape character area. Although the latter of these two comes at a time when Historic Environment Scotland and Nature Scot have been engaged in identifying historic qualities in landscapes at a national level and at a local level.
Thank you very much. That's very helpful. So taking that, got some notes and understanding your thoughts on that. So now I'm going to go to Commander Strawn. Commander Strawn. Could you describe for us, for Ms Hayward and myself, the historic significance of the landscape for your clan?
I'd really be tempted to read out, what I've written here, just a number of bullet points. Clochnaben and all other lands associated with the 13th century barony and forest of Strawn are indeed a part of Clan Strawn history and heritage. To quote Sir Thomas Innes of Lerney, was Lord Lion, King of Ireland 1945 to 1969. The clan itself is like the land it occupies. Heritage and this clan, bound to the chief by the bond of kinship, gives the whole structure an intense and beautiful aspect, which has throughout the ages made the relationship of chieftain and his people to their land, the clan land, something utterly different from the commercial ideas of private property as an investment. That's from Clan Seps and Regiments of the Scottish Highlands. As a brief history of Clan Strawn from 1185 to 1315, the lands were originally granted to a William Gifford, and Strawns then came into possession of the Forest of Strawn, likely through marriage, in between 1203 and 1212. Ranulph de Strawn witnessed a charter of Thomas de Lundy concerning the wood of Trustack in Bankery as a neighbouring freeholder.
I suppose I don't want to cut you off. I understand there's a strong history there. You've got a very strong basis of genealogy, as you've said. But in terms of the landscape itself now, can you tell us the significance maybe of the relevant parts of it initially?
Well, yes. Strawn once extended from the River Dee to the Cairn Mount, approximately 40,000 acres of land. The barony or forest of Strawn encompassed not just the village in the Dee Valley, but also Clochnaben and Cairn Mount. Both are special landscape areas. Castle Hill of Strawn, destroyed by Robert the Bruce. The old military road, this was an ancient drover's road, and the Fuchside Guest House was on the site of an old drover's inn. This road is a direct link for the clan, the Cairn Mount, because it links in with Thornton Castle, and on the Scotland of Old map it shows our crest of arms was from Thornton. That's Thornton Castle, and there are a number of other castles. Kincardine Castle, which now there's only the remains of in Fettercairn, and it's a link to the coast and the Mearns. It's thought that Strawns may well have descended from the Mormers of the Mearns, ancient earls, and had moved into this area. Again, this is a link road, the Clochnaben Road. And for any visitors who are Strawns who want to visit, if they come by car, as they generally have to, they have to come over this road. Well, they do come over this road if they arrive by plane from to Glasgow or Edinburgh. They come up that way and they come over the Cairn Mount, and it's the whole way that you come in. It's spectacular. It's like the land that time forgot. You come over that road. You have Clochnaben right in front of you. Incidentally, that's the clan war cry, is Clochnaben. So really, it's. I mean, we have the idea of Red Indian lands in America, sacred Red Indian lands is accepted, why shouldn't it be the case that a clan which has one of the oldest surnames in Scotland and has ancient associations with that land, that it shouldn't also be recognised as being a sacred land? I don't think the idea is completely unusual, especially when a clan has been driven out and disinherited just because it happened to be related to other people who were seen at the time as not being acceptable people and were then driven out all over the world. It's actually part of the history of the clan that we have so many different Straughns and Strachans living in Australia, Canada, and America. It's because they were driven out all those years ago by really perhaps no fault of their own. This road, you can see it on Scotland of old. The name of Strahan is set within an area given to someone else, Keith, but it links into Strahan and Strachan further down, which goes into the Mearns. That was all Strahan and Strachan land. And it's not that it is now our land. We don't own it now. But it's what everybody looks to try to make sense of a past, a historical past. It's the first thing I do when any Straughns come and visit. The first thing I do is I point to the hills. The first thing I do is point to Cloch na Ben. It will completely destroy any semblance of mystique or to be pointing to man-made wind turbines, which will dominate. I mean, it's fair enough to say you go down one hill and you don't see it. Now you see it, now you don't. Now you see it, now you don't. But you'll be travelling throughout the landscape and you'll be faced with a massive industrial power plant sited right in the middle of our beautiful hills and valleys. And I think that all of that should be taken into consideration. It makes my job so much harder to try and encourage visitors from all over the world. I've actually cooked more than 500 breakfasts this year from April for people from all over the world, from Canada, America, Italy, Spain, Czech Republic, and all of them exclaim when they come that how beautiful the area is. I'm doing a sort of unpaid job for the Scottish Government in terms of publicising this part of the world as being a beautiful place to live and to visit. There are plenty of other countries who are they can go to if they want to. Scotland's not the only place you can visit, but we have a particularly nice tourist, attractive part of the world here. So,
thank you. I mean, you've answered a lot of the questions I had already there. So, I mean, I suppose we understand there's the historic links there. There are strong links there between the clan and the landscape. And you mentioned there that it's maybe not any specific views in particular, but you're talking more about moving around the landscape and just...
I mean, there is the Lady of Strahan, or the Maid of Strahan, as we call her, and that does have a significance, but it would be an anecdotal one. I wouldn't be able to I can give you the reasons why.
Do you specifically know what I mean is, are there any specific views or any specific elements of the landscape that you believe this proposed development is going to compromise in terms of what significance it has for you?
As I say, the Lady of Strawn, which is a particular viewpoint from the Fuchside Guest House, it's anecdotal, I suppose, but it's something I tell Strauns when they see it. There's obviously a birthing point of that image, and there's many of us believe that the Strath is the valley of the Orne, which means little river in ancient Viking. That means it's the valley of the little river, and that the name may have been born of the very hills themselves.
And forgive me if I'll maybe go back to the applicant here. From the Few side and that important view, from looking at map D1, which I looked at a few times over the day, I didn't perceive that there was going to be anything visible specifically from there. Can I just go to the applicants just for confirmation on that, first of all?
Map D1 is helpful in that it shows you the zone of theoretical visibility for the area we're talking about, which is the village of Strawn. There is no potential visibility from the road there. And just to make sure, we ran a wire line. I think that wire line's included within George Moody's hearing statement. Am I correct? So I'm
sorry, the applicant's just saying that at the end of the heritage statement, the hearing statement for this session, they generated a wireframe drawing from the Fuchside Guest House to check whether or not there was going to be any impact on that specific view. And they've confirmed that there won't be. Is that right?
That's correct, yes. Yes, it's attached to the back of the hearing statement, or should be. It certainly is in the electronic version.
Well, that may very well be, but anybody visiting the Fuchs side will have to go up and downhill, and it will be very evident to them. And it'll be very evident, if they're going to go anywhere. I mean, I've been suggesting people climb Cloch na Ben. I mean, it's unthinkable. I mean, to climb Cloch na Ben, what would be the point of climbing Cloch na Ben and seeing such a huge industrial development? And I mean, I don't suppose you've done a wire from my bedroom. There's got 2 floors. I suppose you won't see it on the bottom floor, but you might see it on the 2nd floor or the 3rd floor. They'll just be over the top of the ridge, will they? There's also, if you go up the hill beside the Fuchs side, and as you come down, we have another topographical anecdotal feature of what we call the Devil's Bite. It's a bite out of the hill. It appears exactly the same as Cloch na Ben, and we say the devil took a bite of the ground, and it tasted so good he spat it out on top, and that's what Cloch na Ben is on top. You see that coming over the hill down to the Fuchs side. It's something I point out to tourists and to Strawn and Strachan visitors, and so you'll see I'm sure you'll see all the Windfarm from there as well. So that's my only points on that.
No, I thank you for your involvement there, and I do appreciate and we understand what you're talking about there. There are certain places in the landscape, and not just certain views or places. You're talking about the actual just experience of what you're saying is a mystical place. So we understand your position on that. We've taken what you've said about the intangible, and we've taken the guidance from SPP, and we'll take all this fully into consideration. And we are going to go and observe the maid tomorrow morning, and we'll take that into consideration as well. So thank you very much. Can I just ask if there are any other matters relevant to this session that parties would like to raise before we close for our comfort break and come back for the final one?
I have no other points to raise. I take Commander Strawn's points entirely, and that's what I would be referring to as intangible cultural heritage. It's that people's association with their landscape.
Okay, on that basis, I'll draw this session to a close and suggest that we break for 20 minutes and come back at 3:15. As all of our participants in this session looking around the room have been present throughout the week, I'll not revise the housekeeping or revisit the introductory remarks and whatnot. This session is going to focus upon the draft planning conditions for the proposed development, and participants have been supplied with an agenda again to help steer the discussion. For the benefits of those following along online, my name's Stuart West, and I'm joined this week by Ms Haywood. We've been appointed to consider the application for 26 wind turbines at Glendye and to present a report to ministers with our recommendations following the inquiry. I'll now ask parties to introduce themselves. Those people that are taking part in this session, starting with the applicant.
Good afternoon, sir. My name's Nicola Martin. I'm a partner with Wright Johnston Mackenzie and have been instructed by the applicant, Glendye Windfarm, to speak in this condition session. Thank you. Oh, sorry, could I just add that I'll be joined as necessary and as may be helpful by Mr Baird, who is project manager for Glendye Windfarm Limited.
Okay. Would you need an additional microphone for him, or are you okay without?
I think we can pass it, yeah. Thank you.
Thank you very much. And then on to the council.
Well, I'm agreeing with Nature Scott.
Just got a little bit of an issue with the microphone there. I wasn't picking anything up, I'm afraid.
I don't know why. Is that better? So I'm appearing both for Nature Scott, and to my furthest to my left is Karen Mitchell, who's an operations manager with Nature Scott, and immediately to my left is Jennifer Heatley, who's an operations officer with Nature Scott, and their full roles and experiences, as far as necessary, are set out in Appendix 1 to the statement. To my right is Elizabeth Tully, who I've already introduced, senior planner with the Strategic Development Delivery Team, and to her right, Ewan Brown, advocate. I should have made it clear, and perhaps I should formally do so now, that for the last two sessions, I was appearing on behalf of the council only.
That's excellent. And representing a number of neighbouring estates, we have Mr Kelly.
Good afternoon again, sir. Good afternoon, ma'am. Yes, I represent a number of estates on this matter of the proposed conditions. If I can just say that I'm aware that sometimes the discussion of conditions can get quite tedious and detailed, and therefore in my hearing statement I tried to be as precise as possible as to the concerns, so that parties could help you by responding rather than necessarily being a great forward and back debate on matters. So I hope that detail helps the discussion go quickly this afternoon, sir. Thank you.
Oh, thank you very much. So the applicant submitted an updated list of draft conditions on the 16th of August. Can I just check everybody has a copy of that document? Yep. It's intended, as the agenda says, to work through the list of conditions where there remains some disagreement between the applicant and the council. As I've read it, that is conditions 12, 13 and 27. And Mr Kelly and Nature Scott have also referred to a number of conditions within their hearing statements, which we could also discuss. These comments were obviously based upon an earlier iteration of the conditions, so it may be the case that certain concerns no longer apply. I will just quickly list the numbers of the conditions that I understand there'd like to be some discussion on for ease of reference based on the list. So when we look at the updated list, that would be conditions 1, 2, 5, 6, 9, 14, 20, 21, 23 and 24. So these would align with those conditions that are listed in the agenda. Can I just check that that covers all of the conditions party would like to discuss today? Yeah. Okay. So there's no additional ones to add to the list. Are we in a position to reduce that list any further? Mr. Kelly, are there any from your list, from your original statement, that you believe have been updated to take into consideration? Oh, sorry.
Trying to work off several documents here. It's probably just as well to work through the conditions, and if I have no concerns when we come to a condition, I'll just say no remaining concerns.
Okay, no problem. We'll work our way through that list then, as I've just put out. So we will then begin with, unless there are any questions before we begin and we start on this list. No? Okay, so we will begin with condition 1. So I have Mr. Kelly's statement, and I'm sure other people have that. So I'll just hand over to yourself, Mr. Kelly, for condition 1, just to make the point.
By way of update, I can look at condition 1 and 2 together. This is the section 36, condition 1 and 2. I look at them together, and I suppose my remaining concern is the reference to final confirmation, final commissioning. I know this is a fairly standard wording, but it leaves open the scenario of the developer, the implementer of the wind farm, never actually completing the commissioning of the development, and therefore, in effect, it becomes an open-ended consent. It may or may not happen in practice, but my preference would be to have a firmly defined commencement date from which the consent period applies. And if the applicant felt that the consent period had to be longer than 30 years to accommodate that, so be it. I have no concern with that. I just think that the date from which the consent runs should be clearly defined.
Thank you, sir. The definition of final commissioning, which is on page 43 of the conditions table, provides for an alternative, but provides a final cut-off date of 36 months, whichever so it's either, to read from it, it means the earlier of the date on which electricity is exported on a commercial basis from the last of the wind turbines, or date falling 36 months from the date of commencement of development. So it's the earlier of those two, which I think addresses Mr. Kelly's concern about a cut-off date.
I'm happy with that definition, and it does address the issue. I'll leave it with you to see if there's any way that caveat could be included in the condition, but I'm actually happy with the definition as set out.
Perfect. Does that cover your concerns re 1 and 2?
Sometimes I think it's easier to work in an old-fashioned hard copy.
Sir, I could provide a hard copy to Mr. Kelly.
I'll manage this now, I think. Thanks. In the commencement, 6 years, again, it seems to be standard. It was probably more a point I'll make in the closing submissions tying back to policy. If the development is to address a climate emergency, then 6 years is a long time to effect treatment.
Sir, if I could assist with that, my client would be proposing to start within the 5 years, if that, and would be happy to agree 5 years if that assists.
Thank you very much. Would 5 years be?
It's an improvement, yes.
Thank you. Okay, so taking 1 and 2 aside, we're going to move to item 5, to condition 5, sorry. And this is a comment from yourself again, Mr. Kelly, about monitoring of the implementation. Would you like to add anything to that? Or could you just use your mic? Sorry.
My concern here comes from my experience, and it's now one of these cases where Ms Hayward was involved, Falago. We had a similar type of MOD objection followed by an MOD condition, and in the implementation of the consent, it ended up becoming impossible for a member of the public to actually identify what the final approved mitigation was, how it worked, and how it related to the original objection from the MOD. In fact, in the end, it appeared that the MOD were provided with a new bit of kit that didn't actually relate to the original objection. So what I'm seeking here is simply an availability of transparency so that an interested member of the public, including my clients, can actually follow the process of the mitigation condition being complied with and implemented. And that really is simply what we're looking for.
Does the applicant have any suggestions on how that could be managed, or any views on that one?
So the proposed mechanisms within this condition are tried and tested in most cases. I think there is always an exception. The documents would be in the public domain, and if not, I would suggest if there was any party that was particularly requiring cited documents they could not request, there is the option of freedom of information requests. The mechanism does provide for the scheme to be submitted for monitoring of the implementation. And the provisions there as far as ensuring that there is the appropriate mitigation provided would be in place as a consequence of the imposition of that condition.
Does the Council have any views or anything to contribute to this one?
Thank you, sir. All that I would add is if the Council were in receipt of documents, then they would generally be placed on the public planning register, so they would be viewable to the public. That is with the caveat that, you know, if it's sensitive information, that wouldn't necessarily be visible. It may be redacted. But I mean, I can't comment as to whether that would apply here. I don't know the technicalities of the MOD information.
I think this condition is actually proposed to be attached to the Section 36 consent, which is a matter for the Scottish Government in any event, not us, not our part of the Scottish Government, but the Energy Consents and Deployment Unit.
Ultimately, that tends to be the issue, in that, unlike what the Council would do, the Energy Consents Unit tends not to publish the details of subsequent documents submitted following the imposition of a condition. It's maybe not something we can resolve at this inquiry. If the document went to the Council, then subject to redaction, it would be placed on the Council's e-planning portal and we could see it. But generally speaking, for Section 36 conditions, the subsequent correspondence is not placed on the ECU web portal, and that gives rise to the concern I've expressed.
Thank you very much for raising that. We've taken a note of that, and we'll take that away with us. Thank you. The next item that was referenced is condition 6. Again, that was a reference from yourself, Mr. Kelly. Is there anything you'd like to specifically mention on this one?
Sir, it appears now from reading the condition that the condition only relates to infrared lighting. That being the case, I have no concerns.
Okay, thank you. Can you just confirm that's the case, just for the record?
Yes, sir, that is the case.
Okay, so the next on our list is condition 9, I think it is now, as opposed to... So 9, the appearance of the turbine. I think that you've suggested a basic starting point with a specified hub height and blade length. Would you just like to...
I would stress, sir, here that the intention is not to prevent future changes to the ratio of hub height to blade length, but just to provide a clear starting point so that the public, but especially the Council, can consider where any future proposed changes to that ratio are material or not, and whether it requires the submission of further information. So, back to my basic point, I have no wish whatsoever to stop the applicants applying for a variation. It's just to provide a base point from which the Council can consider any changes.
So, there is a specification for up to 149.9 metres in there.
Sorry, I'm not hearing what you're saying.
Sorry, there is the detail to 149.9 metres to tip in the condition. We have agreed the detail with the Council, so unless the Council now consider additional specification should be required in this condition, we would say that the detail that's in the EIAR about the likely type of candidate is a guidance enough at this point in time, and it's accepted practice that the final turbine model will be set prior to commencement of development and the details of it submitted under this condition.
Yeah, just add that I'm content with that.
Is there anything... We have your views on it, Mr. Kelly, but if there's anything further you want to add at this point, you let us know. So moving on to number 12, which is the first of the conditions in the list, where there is disagreement between the applicant and the Council. Can I invite the applicant in the first instance to explain your position?
Sir, in summary, our position remains as set out in the note on the conditions table. We consider that the requirement for decommissioning does require to be kept at this point in time, to be monitored and agreed, the details to be finalised. The there is a provision for a strategy to be committed prior to commencement of development, which will set out the framework for the decommissioning to allow appropriate level of bond to be assessed and agreed, and set out the future, the baseline for then proceeding to the next stage in the condition as set out, which would then be the 24 months prior to decommissioning, for the details to then be worked up using the pre-commencement baseline. To set the level of detail that is required by the council at this point, we would say is unnecessary, and it would not assist with the actual securing of the provision for the decommissioning. The fact that it may assist the council in their management of the process is not a reason under the circular for the imposition of a condition. While it may be useful for the council to have that note, we would say that those details are included in the EIAR and the SEMP provisions already provided in the EAR. A lot of them relate directly to that level of work and detail. Thank you.
Thank you, sir. Yeah, I think essentially this is just a dispute as to the level of detail that we would be looking for. You know, the argument has been made that the condition includes, you know, a scheme to be submitted, but I think essentially what we're proposing in our proposed condition is just clarity as to what we would expect to be included within that scheme. I appreciate that, you know, the scheme would be submitted to us for agreement, but it's really just getting ahead of the game and just setting out and being, you know, upfront as to what we would be looking for as part of that.
Thank you. Unless any party's got anything to add, as I say, with this one, we're taking cognizance of the different views. We're not here to make a decision or to try and encourage anybody to change their minds at this point, but just to understand for our own notes. So we'd move to look at number 13 next. And we'll do the same again if that's okay. We'll start with yourself and move across the room.
Yeah, so I think it's very much the same position, that the requirement for a financial guarantee is addressed and is provided. There is provision for a 5-year. There's provision for a 5-year review of the level of the bond, and to monitor that. And our view is that the drafting of that condition secures what is necessary to address and the reason cited for that condition. We've nothing further to add, sir, unless there is a specific point that we can assist on further.
Is there anything?
No, essentially another disagreement as to what we would be looking for, what we need to see as part of the scheme. Sorry. Stuttering.
Can I just be clear as to why you have disagreed? I'm not clear why you have disagreed with what the applicants are proposing.
So to address the points in the applicant's comments, they're saying that the detail proposed by the council, it's going to be put in place through the scheme to be submitted to us and agreed by us. And again, it's just us being upfront as to what we are expecting to see as part of that scheme. So there's no shocks. And then there's the second point to make about the approved financial provisions need to be kept in place until the site has been decommissioned, and therefore it's not necessary for the guarantee to become invalid. Include provision for the guarantee becoming invalid as the condition already requires the development to keep financial provisions. Essentially, we need that to make sure that the developer comes in with another financial guarantee. Otherwise, there's kind of no hook. Sorry. Just a second.
Sir, if I could just...
We'll just let you finish the point first.
Thank you. If we don't have the provision provided for the cessation of operations, then we've no enforceability of that matter.
Thank you, sir. The scheme would be submitted for the approval of the council, and it will be for them to decline to approve it if it did not contain everything that they required at that point of submission of the scheme.
Have you anything you want to add to that?
No, thank you.
The next on our list is looking at micro-siting, number 14, and that's a suggestion by Mr. Kelly.
Thank you, sir. The matter is now addressed in Roman numeral 2 within the final condition, so no other concerns.
Thank you. So I'll take people to condition 20 on the Clerk of Works. Again, Mr. Kelly.
Two points. The word independent ECOW is used in the last part of the final condition, talking about the decommissioning stage. So I see no reason why the word independent shouldn't be included at the start of the condition as well. I think it should be obvious to everyone what the word independent means, but I should just explain that in the case where I submitted the enforcement notice for Craig Rearbach, the Highland Council permitted the Windfarm company's own consultant team to also be the independent ecological clerk of works, and I don't think that constitutes independent. The other concern about the publication of the material on the Council's website, the Council have already confirmed that material submitted to them will go on to the e-planning portal, so no remaining concerns on that. So the only change I would seek, sir, is right at the start of the condition for it to be changed to an independent ecological clerk of works, which will then tally with the last paragraph.
Sir, the second sentence of the proposed condition requires that the identity in terms of appointment of the ecological clerk of works is submitted to and approved by the council, and we would say that that provides a very robust safety mechanism to avoid the risk of that sort of situation developing.
Do you have any views on that yourselves, Mr. Lee?
I think, we checked the wording of the Craig Rearbach condition. It was a different authority to ourselves, but there was no provision to provide agreement for the identity, and I think the council would just make clear that we would be looking for an independent.
Okay, thank you. Moving on to the next condition, number 21. Mr. Kelly.
I took advice, sir. Thank you, sir. I took advice on this condition from my clients with their experience of land management. They regard it as being a condition that will be very difficult to deliver properly. The questions are there, maybe for the Council on Nature Scott to answer. Who will monitor it? What will be the results of non-compliance? Does it relate to bird strike, where that would also provide for carrying and feeding raptors, and the condition refers to livestock and deer. And on first reading, I wasn't quite sure if they were thinking some livestock and deer might be killed by the turbines, but I think it's just fallen stock that's being referred to there. It's an interesting condition, and perhaps it might help you understand it if Nature Scott said a little more about it.
Happy for Nature Scott to comment.
Thank you. Yes. I think this condition is really about sort of, I don't like the term belt and braces, but it is designed to try and reduce the risk of impact within that 200 metres of the turbines. Sorry, yes, it is. So by removing carcasses and doing, well, searching for carcasses and removing any carcasses within that 200 metres would reduce the risk of some species of bird that do sort of, do rely on carrion. So I think it has been used at other wind farms as a sort of, perhaps not a condition, but perhaps as part of a management plan or ongoing work. So that's sort of how we see it, as sort of, a good practice, thing. So the fact that it's a condition, they've obviously highlighted it.
So in terms of monitoring and enforcement, which for the condition to be necessary and enforceable, who would you envisage monitored it, and would it be enforceable?
Well, we would envisage the applicant the developer being responsible for, carrying out those works in accordance with that.
Enforcement's probably more of an issue for the council rather than Nature Scott, so I shall pass it to my right on that regard.
Yeah, just to speak on enforcement, I think our enforcement service, our enforcement team would require breaches to be reported to them. So maybe through Nature Scott or through the ECAO or someone like that who's monitoring the site, we would take on any breach and consider it appropriately.
And you think that you said that it's normally as part of a management plan. Do you think it's more effective or appropriate to be a specific condition rather than part of? I know we have a habitat management plan as another condition here.
I think it's identified in the EIAR as required as mitigation, so I think that's why it's been transposed into a condition. I think that's what's happened there.
Sir, if it would assist, subparagraph 3 requires the submission of a review every 3 years. The applicant would be prepared to submit a report at a sort of another period, maybe annually, if that would assist with the monitoring.
Can I just say, sir, that an annual report going onto the council's e-planning portal would enable my clients to check whether their concerns remained valid or not and respond to the council. I would be happy with the condition if it was amended to take up Ms Martin's suggestion of an annual report.
Thank you very much. So moving on from 21, we are actually going on to 23, which is the peat and habitat management plan. We'll start with yourself, Mr. Kelly.
Thank you, sir. This is not so much to do with the wording of the conditions itself. It's down to the practicalities of the Council's monitoring and enforcement service. As I said in relation to Craig Reabach, things were going wrong in terms of peat management for something like 18 months before any action was taken. And in that case, notwithstanding the fact that there is a revised peat management plan, the situation on the site is that what is on the site is not what was approved, and it's certainly not what was assessed in the environmental impact assessment. So, cutting to the short point here, my clients are looking for assurance from the Council that if this wind farm is consented, then the peat management plan will be rigorously monitored and enforced.
Well, we'll go to the Council first.
Yeah, thank you, sir. The peat management plan is specifically referenced as part of the Ecological Clerk of Works who would monitor this. So from within that condition, the Council would receive a monthly report, and we could pick up any breaches from there. And it's also, you know, the duty of the Ecological Clerk of Works to report a breach at the earliest practical opportunity. And from that, I would just go back to, we would take any report of a breach seriously and be passed to our enforcement team.
Do any other parties wish to add anything to that? SNH or the applicant?
No, sir. Thank you.
Mr. Kelly? No. So the next on the list is the Regional Eagle Conservation Management Plan. We'll start with Mr. Kelly.
I've tried to help, sir, particularly in this condition, with setting out the concerns expressed to me by my clients. So far, we've had some clarification that the plan is not going to require land use management changes on any of the estates. And we've also had clarification that there will be no need for physical access to any of the estates, but at the moment the other questions remain unanswered, and pending seeing sight of the eventual plan, redacted or otherwise, we're not clear how it's going to deliver the benefits. And as we said right at the start, we were slightly surprised that Nature Scotland went down the road of mitigation in terms of golden eagle, potential harm to the golden eagle, as opposed to avoidance and simply opposing the wind farm on ornithological grounds, as our SPB have done. Thank you.
Is there anything from this side in response at the moment?
Well, in terms of Nature Scott's position, and indeed the Council's, they're both content with that this can be secured by condition, and that it's one of those cases that a plan is to be produced so that the detail that Mr. Kelly is seeking to ascertain will be in the plan in due course. It's too early to provide it now, in a sense, but the condition will satisfactorily ensure that the plan comes forward. And it's a, whilst Nature Scott has experience of a similar plan, albeit secured differently at Dornell, it's a plan that's capable of working.
Can I just ask, is there any danger that you can't reach agreement on a plan?
Well, there's always a danger, but as I understand the way the condition's worded, if agreement's not reached, then the development...
well, that's our concern about it, that no development shall commence until details of the plan have been submitted to and agreed, which implies that Section 36 consent could be granted with this condition attached to it. But if the plan isn't agreed, that Section 36 consent cannot be implemented. That's really what concern is about.
Well, perhaps answer that in two ways. First of all, there are a number of conditions which require plans to be agreed. Yes. So it's no different in principle from that. In practice, one can see that it may involve broader aspects, but again, I hark back to the plan that's been put in place at Dornell, that it's not the first time that this has occurred, and we don't envisage having had some further information as to the likely approach of the plan and what is contemplated, without that being written into the condition at this stage. We have sufficient, had sufficient information that we don't think that that is a real concern. We think, you know, with both sides acting reasonably, a plan should be capable of being agreed. And that's as I understood the position. There are a suitable number of nods to my left, so I'm happy to leave it that way.
And with just maybe a little follow-up, maybe a plan can be agreed, but are you confident it can also be implemented? Mr. Kelly mentioned that it had been indicated that there wouldn't need to be access taken to third-party land, but is that the case?
Sir, Ma'am, the outline habitat Golden Eagle, the Regional Eagle Conservation Management Plan has been agreed with Nature Scott, and that sets out the framework for what the actual plan would deliver. And it follows very closely the successful plan that has been adopted and implemented at Dunmaglass, and that there is information in the ornithology section of the core documents that you have that you could turn to if you wanted to see the sort of plan that might be implemented there. Otherwise, we agree with the approach outlined by Mr. Finlay, that this is a suspensive condition which is applied, requiring the submission of a plan which follows the pattern used in a number of conditions.
So just to be clear then, you're saying that the plan has been agreed, or the principles will follow the draft plan, which is that core documents 25/7?
Sorry, Ma'am, I'll just check.
Okay.
Ma'am, that's the SSE, that's the Dunmaglass matter. There is the draft habitat management plan was submitted as part of the submissions. I think probably it's CD 25.3, but I will check that. It was submitted as a confidential document, so it would have come to you, Ma'am, and to you, sir. And that was agreed with Nature Scott.
Okay.
Can I just say, ma'am, that the discussion really reinforces my concerns. If you look at the extent of my client's land ownership around the host estate, and if you bear in mind that much of the host estate is now under different ownership of Aviva, we find it very hard to see how this could progress without any form of involvement or agreement of such extensive land holdings. And of course, as Ms Martin has just confirmed, the information that is before you as to the draft principles of the Regional Conservation Plan is not available to me or any of my clients. So really, we're very much in the dark as to this, and it's potentially quite an important aspect in this case. I'm not sure it's resolvable just now, but you certainly have my client's concerns, and you certainly have the map showing the extent of the land ownership on 3 sides of the application host estate. Thank you.
Okay, well, we have parties' positions on that, so that's quite clear.
But I think we're addressing a more general planning point than a simple condition. Suspensive conditions are imposed on very many permissions, and there's always a risk that they won't be purified by the approval of what is to be submitted. That's a risk that goes beyond this site and beyond this condition. I think that risk is mitigated in this case by the extensive discussions which have taken place between the applicant and Nature Scott. both parties have a pretty good idea of what they're trying to achieve, so that risk is mitigated. But the risk is always there. We can't get away from that. Sorry.
Can I add? I think the appendix that Ms Martin was looking for was CD 25.2, Appendix 5. And secondly, I think the way the other, Mr Kelly's concerned, there can't be enforced access against his clients because his clients aren't signed up to the condition, but the way that the condition works or has worked elsewhere is by cooperation, and that's seemed to be successful. And Mr Kelly's clients may take a particular stance, but it's our, or Nature Scott's understanding that that's estates are usually cooperative.
Okay. So moving on from that, the final item for discussion is number 27. And I'll pass to the applicant.
So this is a difference between the applicant and the council again, which relates to the level of detail that might be required. The general principle of the level of detail to be required. Our position is that the compensatory planting to be required can be submitted in accordance with a plan, and that the detail set out by the council and proposed by them is unnecessary. Again, it's the council's reasons for that detail I don't think stands up in terms of the circular, and the fact that it's required so that to ensure everything is included within a scheme to a satisfactory level. Again, the provision of the planting scheme would be submitted to them, to the council for approval, but for so if it wasn't to their satisfaction, they could refuse to approve it.
Thank you. Yeah, just as Ms Martin set out, it is a dispute as to the detail of what we're requesting. And it basically comes down to we're trying to add precision into the condition, just to make sure that everyone knows exactly what is expected to be included within the scheme. We appreciate the scheme will be sent to us and approved by us, but it's just really to be upfront and precise about things.
Thank you very much, and thank you everyone for getting through that list. So that is all of the items that, all of the conditions, the draft conditions to be covered by item 2. And unless anybody has any others they'd like to say a word on, we move to item 3. Yep. So moving on, within his hearing statement, Mr Kelly suggested it might be appropriate to add a condition that an independent planning monitor officer be appointed. Before we look at that suggestion in any detail, can I just go around between parties and see if there are any further suggestions for additional conditions that we might want to consider today? No. No additional. So, Mr Kelly, could you please outline your thoughts on the planning monitoring officer and why you think it would be a necessary condition, and then we'll hear the views of the applicant and the council.
As I understand it, sir, the Energy Consents Unit now take the approach that this is a standard provision on deemed planning permissions associated with Section 36 consents, and in many ways it's simply to help the council with the workload of monitoring and then enforcement. But as I understand it, it's now virtually a standard condition.
And is that standard in addition to the Ecological Clerk of Works post?
Yes.
So before we go to the applicant then, is there any views on that from the council? I don't know if you've used that condition previously.
Sorry, thank you, sir. It's not something that we have used ourselves, but it is something that we have seen coming through. I know we have been consulted on a Section 37 development, and that is suggesting a PMO condition. But I just would agree with Mr Kelly. It does seem to be standard, having checked some previous decisions coming through from the ECU, and it's not something that the council would contest.
Sir, our position is that the ECAL would cover the monitoring requirements that the PMO would be proposed, the role of the PMO. The ECAL condition sets out the detail there for the project manager to report to the ECAL. The ECAL is required to report to the planning office, the planning authority, incidents of non-compliance with all the works that are the responsibility of the ECAL, which cover the construction activity period and the period of post-construction restoration works, which was the main time that the monitoring is required.
And do other parties, Mr Kelly maybe, that suggested this, what additional monitoring would you envisage that a planning monitor officer would undertake in addition to these listed that the applicants quoted there?
The responsibility of the planning monitoring officer would be to monitor compliance with every condition, not just the work that would come under the control of the Ecological Clerk of Works.
So if it was considered necessary to impose a condition requiring the appointment of a PMO, we would ask that it was limited to the period of construction and post-construction restoration works.
Sir, I would be happy with that for your note.
Sir, if I could just come in. I don't see any reason why the PMO and the ECAL could not be the same person, just with two different roles, if that would help.
We'll take those into account. It's yeah.
Before you move on to talk about item 4, just going back to the conditions, and I'm sorry we didn't raise this before, looking at condition 29, which is about borrow pits. That was drafted before the discussions at the inquiry, and it relates to what's in EIA Appendix 4.1, the borrow pit appendix. And there's no warning given to the council of this, but I think if you look at subparagraph 3, the detailed plan for the sequential working, which shall prioritise 4, then 3, then 1, may not be a good idea. It may be best to leave the scheme as a scheme at large without trying to constrain it in the way that subparagraph 3 does. And the reason I suggest that is that clearly one of the concerns of the council is the colour of the stone which is applied to the track. And therefore, if there is some choice, I have no idea, some choice of stone as between the 3 borrow pits, and one of those borrow pits may be preferred to the other in terms of the surface application to the tracks. If you go and exhaust the stone for other purposes and that preferred colour is not available at the time of surfacing the tracks, that would be a poor idea. So a rigid prioritisation of borrow pits may not be sensible in that context. I just make that suggestion.
Yeah, no issue with that.
Okay, thank you very much. So there was no other conditions that people felt should be added. So if everybody's happy, we'll move to item 4. During item 4, we'll have a look at the requirement for legal agreements, planning obligations. There has been a little debate. Well, there seemed to be in earlier submissions regarding whether or not the regional legal conservation management plan could be controlled solely by planning condition or if a legal agreement was necessary. Before we look in detail at that matter, can I just check whether there are any other suggested requirements that are either suggested or in dispute, any other legal requirements?
So the regional Eagle Management Plan is no longer in dispute so far as my clients are concerned, and we accept that that can be dealt with by condition. But the remaining, skip my, both, as I understand it, both Nature Scott and the Council have a concern about the peat habitat management plan insofar as it relates to peat off-site. And so that's the ambit of the dispute.
Would you, seen as though there's, well, first of all, are there any other disputed issues? No. So if the applicant's okay with this, we'll move on beyond the Regional Eagle Conservation Management Plan then, if that's no longer in dispute.
I have a comment on the legal issues for the management plan, which maybe I can just say, and then you can move on to the habitat management plan issues. Put simply, my client's position can't be finalised until they see some more detail. The principle is that should the implementation of the plan go beyond actions under the control of the council and the applicant, then we would feel a legal agreement would be needed. But obviously I can't finalise on that until we see precisely what is involved in the management plan. But the test for me would be, can all the measures be implemented under the control of the council and the applicant?
Given the example management plan that you've referred to earlier in the session, is that controlled solely by condition, or is there different factors there at play?
I think, I'm not entirely sure of the actual mechanism, but it's likely that some form of agreement will be required, a bit like there is with a condition which requires a bond. The condition is a suspensive condition which will then give rise to some form of underlying agreement. And that's what I envisage in broad terms is likely to be required in this case, because there's for instance, there's payment of an employee, and the funding for that will have to be secured. But there's no reason why that agreement needs to be in place at this stage, just as with a bond.
So the provision of the plan is to be secured by suspensive conditions that we've already discussed. That plan may well include measures to provide for the funding of that plan, but the outline plan that has been submitted and discussed and approved by Nature Scott does not involve the payment of monies directly to the council. It sets up a management panel that does not necessarily, and in fact, my understanding is it doesn't involve payments at all to the council. So the scheme itself will be submitted and approved, and may well include requirements that payments are made, as indeed would be the scheme for the ECOW, as indeed would be the proposals for schemes under the SEMP, for example, to carry out particular works under that. It's no different from any of those other suspensive conditions.
Okay, thank you. In terms of the peatland management plan then, moving forward, could you just maybe outline the issues there, unless there's another point to be made?
I think I'm just asked to make it. Just asked to make it clear that the council's hasn't approved any of the specific financial provisions in the plan. They're to be agreed. That's part of the agreement, but I don't think that undercuts anything that Ms Martin has just said. In terms of the peat plan, if I can call it that, rather than getting caught up in too many initials, the concern can be briefly stated, and I think it's the same concern on behalf of both clients as set out in Nature Scott's statement. It concerns that part of the peat restoration that lies out with the applicant's control. And just looking at the circular, which I think is CD 12.4 on conditions, para 3 and get my paragraph number correct, I think it's 36. And 36 make comment as to the extent of need for control. The question is whether the applicant has sufficient control over land to enable works to be carried out. That's what para 36 says. And at the moment, my clients sitting to the left and right remain unconvinced that there is sufficient control as a matter of not necessarily legal requirement, but policy requirement to be satisfied that a condition will secure the benefits which are sought to be secured, which led to the removal of Nature Scott's objection. In part of the works are on site, and we're satisfied that there is sufficient control, obviously in respect of those parts. So it's that sufficient control point that we're raising. And we understand that the applicants have an option agreement, but we've asked to see the terms of that and have not been supplied to them. And we've made it clear we don't need to see the commercial parts of the agreement. It's those parts which would enable them to have control. So that's where we are. It's not a detailed concern as to the wording of the condition. It's the extent of control.
Before we go over to yourself, we'll just check if there's an additional.
Just check if I've misrepresented something there.
So, once Mr Finlay has instructions, can I say something by way of clarification before Mr Trinker and Ms Martin, before they respond comprehensively?
Nothing to add.
Mr Kelly.
The issue has arisen from our side because Scottish Woodlands, on behalf of the new owners of Glendye estate, are consulting with the neighbouring estates on the plans for restoration and planting of woodland on the remainder of Glendye estate. I was not present at the meetings myself, but I was told of what was said. My clients asked Scottish Woodlands and emailed them subsequently to specifically ask them, do the applicants have control of land out with the application site to undertake works? And the reply was received saying that the applicants have no influence over Scottish Woodlands and what Aviva will do. Now, I honestly do not know if that's true or not. I'm simply following up from what Mr Finlay said by reporting what Scottish Woodlands have told my clients. And funnily enough, Scottish Woodlands are actually holding a consultation event in Strachan or Strawn Village Hall tonight, I think, on their plan. Yeah, on their plans for the estate. So, as I say, I don't know whether that is correct or not, but it is what Scottish Woodlands are telling my clients.
So, if I could just start out. The submitted with CD 25.3 is an option layout plan. And that, yep. It's ornithology. It's the ornithology response, the update to the change in the ownership. That is the option plan taken from the option agreement that my client has in respect of the Glendye moor. And if you then go to CD 1.19, which is the additional information that was submitted to show the proposed peatland enhancement work. There, scrolling down through that, there is a plan, a three-dimensional plan, which shows. Sorry, Ma'am. Electronic page 7. And that includes an area to the top of the page, edged in a kind of a greeny yellow colour. And that area is included within the area shaded green, which is outlined in red, which shows the option area at CD, the extract of 25.3.
Could I just have those colouring again? So the extract on CD 25.3 is presumably the blue area.
So no, the blue area is the Windfarm area.
Yeah.
The green area is the wider Glendye moor area, all of which
is under option.
No, the green area is the whole of the Glendye moor area. Yeah. Which has now been sold as of December, I think 2021, has been purchased by Aviva par equity. The area which is shown edged red on that plan is the actual area over which my clients have the option.
Yeah, I see that in the bottom left corner.
Yeah.
So just to be clear then, there's an area of blue, which is the Windfarm site, then there's a big area of green.
Yes.
And part of that big area of green, which is outlined in red,
yes,
is the bit that you have your clients have the option. Okay.
Yes, ma'am. And how that interplays with the proposed peat habitat improvement area is shown in a number of places in the documents that you've received, but perhaps the easiest one is CD 1.19, which shows that three-dimensional representation of the site with the proposed habitat improvements. If I may go on, there is also reference to riparian planting, 11.5 kilometres of riparian planting, which is proposed as part of the habitat enhancement measures. There is some of that, the water of char extract, some of it goes off out of the shaded area blue into the green area again, so my clients have the option over that, and that can be seen on the three-dimensional plan, page 7. It's shown in so it's shown, there is a blue line which is the water of char, to the which is to the bottom of the rusty red outline, which shows habitat enhancement area. Sorry, that shows a development footprint outline, I think. The development BNG area it's indicating. But there is a blue-green line which sort of ziggles across at the bottom there. And that's the water of char riparian planting corridor. And there is
so that's the bit where there's arrows which go up the top left of that diagram, which says continuous and discontinuous riparian tree and shrub planting.
Yes.
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 And that's all in the control of the applicant.
So part of it goes off into the green area shown edged in red under the option agreement with the Glendye estate, and then on the other side of the development area, there's a part of it as well that goes off into the Fasque estate, over which my client also has an option agreement for carrying out various works, including the riparian planting. And that the stretch that is out with the site, the development site for the riparian planting, is approximately 1.5 kilometres of the 11.5 kilometres.
Thank you. Can I just check with the council if they've had sight of this plan prior to now?
Obviously, technically we have, because they're submitted documents, but I don't think we've had the explanation until now that we've just had. I mean, I may be wrong as to that, but that's, I think, the first time we've had that explanation. Be cautious as to what I say, but what we have are the plans that would be attached to the option agreements. If there's sufficient control, is likely to depend upon the terms of the option agreement. So it's a partial answer at best. Obviously, in some cases, different, particularly I know on behalf of Nature Scott, they may or may not demand to see a particular agreement depending on the particular circumstances. But in this case, where land has been sold off, when you've heard what Mr. Kelly's said about the landowner's intentions, and their statement, then this is a case where, certainly at present, unless I'm instructed otherwise, we don't consider there's sufficient evidence of sufficient control.
Sir, Ma'am, there's, if I can just confirm that the original option agreements were entered into last summer, 2021, following the sale of the land of the estate. My clients entered into a novation agreement releasing Glendye estate owners from their obligations under that agreement, and Par Equity were party to that agreement, and the whole thing was just taken over by Par Equity. So there's a novation agreement which just transfers the obligations that were contained in the original option agreement.
Just to add to that, a general comment from Circular 4 of 1998, paragraph 38, advises very directly on the situation we're now addressing. Not only as Mr. Finlay, I know, agrees with this, no legal requirement for reasonable prospects before imposing a suspensive condition, nor is there a policy reasonable prospects test advised within the circular. There was, I think, a few years ago, the ministers made an exception to that when they advised in relation to aviation conditions in southwest Scotland, but that was an exception. Under 4 of 98, there is no reasonable prospects policy test.
Okay, well, I think we've taken on board all that was said there. So, unless anybody else has got anything else to add in this regard, we would look to move to item 5, which is just any other relevant matters for this session. Well, before that's very nice, and we've broken our record and finished even earlier today. People will be happy, but we do have one or two things to just say, because I think not everybody's going to be with us for Friday's session or for the site visits tomorrow. So first of all, closing submissions. The timetable is outlined on the back page of the pre-examination meeting. Meeting note. So I think it's 2 weeks for council and other parties, and 4 weeks after the end of the inquiry for yourselves. Inquiry finishing on Friday. So from that date. In addition to that, as has been discussed, NPF 4 is likely to be adopted, as will a new local development plan, prior to our report being published. So it would be our intention, upon adoption of those, to seek further written submissions from parties as to how we should be taking those into account. So we're just forewarning you that that will be the case.
So just in respect of, completely understand that in respect of MPF 4, and in respect of the development plan, you've had significant submission already. It's very unlikely to change. Obviously, if there are changes, then that might generate further submissions. But we'd hope at this stage that you wouldn't be expecting, and there shouldn't be there may be nothing to say from either side, because it will be in the terms on which we've been addressing so far.
That's probably so. I think I agree with that. But on the basis that you have got 2 new documents, I assume that you seek a single set of submissions on the date of the second of the documents to emerge, rather than have sequential submissions after each one.
Well, it depends on when NPF 4 will be published, because we don't know when that will be. We have got more certainty about when the LDP will be produced, and we don't want to delay submissions on that to wait for the NPF. So we'll probably do them separately.
I really think that there's very unlikely to be very much to say on the development plan, so that there's unlikely to be I can see Mr. Trinick's underlying concern, which is there may be the combination of the two may give rise to something that we haven't yet considered, but that's likely to arise when MPF 4 is published in any event, and I think sequential, dealing with them in turn is sensible, because at least the groundwork is laid for any further submissions.
You anticipated my concern, which is that a combination of the 2 documents may give rise to the need for submissions. For example, and only for example, MPF 4 is going to be the lead development plan for Scotland, and in a Section 36 context, the degree to which the new development plan is consistent with MPF4 may be an issue on which I will wish to make submissions.
And we won't prevent you from doing that once MPF4 comes in.
That's fine.
So that's fine.
But in terms of the timing for MPF4, I agree it's not certain, but I think we can anticipate that it will certainly be before the end of this year. And if that was the case, I hope you wouldn't proceed to complete your report and not allow representation to be made, because the ministers will be making that decision.
No, the target date for the completion of our report is just before Christmas. So we anticipate that NPF4 will be out by then. But in any event, even if it isn't, and we submit our report to ministers before it's out, then it will still be before the decision is made. So it'll be up then, not to us, but to energy consents units, whether or not you make submissions on it then.
All we can do, I suppose, is see when things come forward at the moment. The only other thing that we wanted to mention is tomorrow's site visits. So we're aiming to meet at the car park at the Fewside Guest House at 9:30. Would all parties be meeting there that are going on the later site visit? Or will we meet in a second location?
Perhaps the best thing to do is to come and show us on a map where it is, so that we know where we're all going, in case we get lost on the way.
We have this excellent map D1 here that you could put some map on.
And Miss Fletcher, if you could come along as well, so you know where you're going.
I'm just going to close today's session for people because I'm aware a lot of you are wanting to get away. So thank you very much for your attendance. For those coming to the site visit, we'll see you at 9:30. And for those people coming to the community session on Friday, we're aiming to start again at 10 a.m. But feel free to come a little earlier. That session, as we said, won't be webcast, unfortunately, because our web wizard is having to leave us. But thank you very much, Ewan, for all your work as well.
Can I just say that neither myself nor Mr Brown will be here on Friday morning. There will be representatives, certainly from the Council and probably from Nature Scott here. I've explained our position to those representing local communities, and that simply leaves me to thank you for your conduct so far and putting up with our giving of evidence. Thank you.